Nice to meet you. Hi.
Good morning, everyone. Welcome. I'm Rimantas Simaitis, Associate Professor from Vilnius University. We are happy to have you here, to host you here for a very small warm-up, not taking more of your time before official start of the conference. Let me tell that we, Vilnius University and Brussels Vrije University, together co-organizing this conference, are very happy to welcome large number of top-level speakers in Europe on these topics of algorithmisation of disputes. And we are lucky having a large number of participants here. Then we started brainstorming with Marco Giacalone from Brussels Vrije University. Shall we do some interim checkpoint of our CREA project, maybe in Vilnius, in winter time? Our primary idea was, well, let's have 5 speakers, a very small seminar for 40 persons, 50 persons. But we are really amazed. We are really amazed with enthusiasm of the speakers to say, well, we are interested, let's go, let's discuss, let's present our ideas to the public. Let's switch on live streaming. We are live streamed on Vilnius University Faculty of Law Facebook profile and Teisė Pro information portal. So if you would not be able to be all the time with us, no problem, you can switch on the computer, model technologies, and you can watch us online as well. And what we have a seminar. This event is called Seminar because the primary idea was like this, with more than 20 speakers and around 200 participants. We are truly happy. And for official opening of a conference, I would like to invite the Minister of Justice, Mr. Elvinas Jankevičius.
Thank you very much, dear guests, dear colleagues. Information technologies are already part of our lives. Using smartphones, driving self-driving car, or translating text in our automatic matter. These all are just a few examples, and the use of modern technologies is also inevitable in a public life, including, of course, in our beloved justice area. The availability of electronic means in courts can improve access to justice, reduce costs, and boost cross-border cooperation between judicial authorities. I'm happy to notice that information technologies have been already introduced into our judicial procedures. Our laws provide for a possibility to communicate with courts via electronic platforms, eliminating the need to leave our offices, especially maybe in such cold winter when it's a lot of snow and raining. Furthermore, our businesses and citizens already benefit from the possibility to recover debts by using electronic court order procedure. Next step in this modernization could be, and probably will be, artificial intelligence. It's a brand new topic across the world and the European Union. Last year, the European Commission issued communications on artificial intelligence for Europe. This important document overviews the plans and challenges in this area for the upcoming years. These plans has also strong political endorsement, as all European countries, including our country Lithuania, last year signed a declaration of cooperation on artificial intelligence. I am wondering how it will change our lives, but it will probably change. However, it is obvious that the use of new technologies should be based on certain values and protection of human rights. Looking from my field of responsibilities, ensuring full respect for the protection of personal data is at most importance. To be more specific, compliance with the General Data Protection Regulation should be guaranteed while enjoying the benefits of digitalization. Furthermore, our common values, such as privacy, non-discrimination, the right to a fair trial, should not be undermined. Cooperation between policymakers, practitioners, and other professionals, as well as sharing best practices, would definitely help us to achieve our goals in the best possible way. So I thank you, the organizations, for a very important meeting today, and I hope we can change our experience. Thank you.
I would like to invite for opening speech Chairman of the Supreme Court of Lithuania, Professor Rimvydas Norkus.
Honorable Minister of Justice, Honorable Dean of the Law Faculty, ladies and gentlemen, first of all, I would like to congratulate organizers for choosing the venue for this conference at this winter time in Vilnius, the capital which has already established itself as a center of fintech, thanks to a highly skilled manpower and a favorable legal framework. I'm more than sure that there is a great capacity for developing a legal tech hub in this part of the world as well, and perhaps this seminar or conference will also act as one of the boosts towards this direction. I was certainly intrigued by the title of the seminar, Algorithmisation of Dispute Resolution, and I came with some expectations here, expecting to learn whether we are still in a science fiction field or whether we have something tangible to speak of which could be used in practical terms, because dispute resolution traditionally has been always in the human hands. Speaking about praetor, arbitrator, judiciary, whatever, certainly people also use certain algorithms when they arrive to a solution in the case. They have to establish facts, they have to find an appropriate legal provision and to apply this legal provision to the facts. This is an algorithm in itself which we are having in our hands. Whether we are threatened in the judiciary by the machines, that's a big question. There is no panic in the judiciary, at least for the time being. As the minister rightly indicated, we use a lot of supportive technologies for communication with the litigants, which should facilitate the access to the courts. However, there was no major steps towards some proposition of the solution in the case. And it goes without saying that the artificial intelligence can surpass the human capacities, that's evident, but it is also predicted that some professions will not be threatened by artificial intelligence. The longest life is predicted for plumbers, electricians, and nurses. So these professions who require some sensitivity and human touch. Whether it is important that the disputes will be resolved by man or by the machine, if I ask you, I think the majority of you would vote for a human resolution, because it's important for us as human beings that there is also a human touch in every resolution of the dispute. We do not want the dispute resolution be purely regarded as a technical matter, because it's important for us that we have an access to a human being who has not only a professional skills but is also a sensitive and experienced person. So with that in mind, I congratulate all of you and I wish you best success in debates of this conference. And I hope that with the advancement of the technologies, we will not lose a human face of justice. Thank you.
Now I invite Professor Tomas Dovulis, Dean of the Law Faculty of Vilnius University, to welcome you.
Dear colleagues, good morning. It's a pleasure to be here and to welcome you on this occasion. And well, this is not a surprise that the Vilnius University is hosting this interesting seminar. Our devotion to the technologies, I mean the law faculty's devotion to the technologies, is very important and very visible. At the law faculty, we're starting, for instance, a new LLM program in tech law, where e-justice will be taught by Professor Žemaitis. So I hope that we are among the pioneers of developing this very interesting and intriguing field of law. But I'm also very glad and proud that we participate in this project, because, well, I think this will be our future, and our future will look like we will be talking about it today. So Tim Cook, just I read the article of his interview. Tim Cook, the chairman of the Apple, said that technologies, algorithms, they will be designing our future, but he's a little bit scared of the technologies. We should always be reminded that technologies will do what we want them to do. And behind the console is always the human being, so who is designing the algorithms. So please keep in mind that we are among those designers today, and it's up to us how the future will look like. So thanks very much for coming. All the best and success to the seminars, and I hope you will enjoy this wonderful winter in Vilnius.
Now I would like to invite Professor Vytautas Nekrošius, who's head of private law department at Vilnius University Law Faculty and at the same time chairman of Vilnius Court of Commercial Arbitration.
Dear colleagues, my English will be not so perfect in compare with the speakers before me, but I will try to do my best. So, dear colleagues, first of all, I would like to sincerely thank for the law firm Cobalt and for Rimantas Simaitis personally for organizing this conference. Really, it's a very, very important topic. And Rimantas is one of the leaders in this area in Lithuania. We have no doubt Lithuanian people, and I hope that the international people know that too. So, thank you very much for this conference. I think that really we will have very good discussion and very interesting discussion. The topic algorithmisation of dispute resolution is not only very interesting, but also relevant to both the public and private system of dispute resolution. Electronic methods of delivery of procedural documents, the existence of electronic cases, which for many have become a matter of course, the increasingly imminent introduction to artificial intelligence into dispute resolution systems prove us the importance of the chosen topic without any additional arguments. On the other hand, all these processes make it necessary to rethink limits of application of some principle of civil procedure and traditional structures. Currently, it seems to me that the main challenges are the problems of application of the delivery of procedural documents by electronic means. This is particularly relevant when we are talking about the first delivery of procedural documents. Is it enough to send documents simply to the email address indicated by the claimant in the absence of the defendant's confirmation that they are accepted? Is it enough to simply send a notice of a claim received in an electronic case to the defendant with a proposal to join the electronic case? And what should we do if the party simply doesn't react to such proposal? These are important and relevant issues. Vilnius Court of Commercial Arbitration for several years has been working with the electronic case system Arbis. We can say that it has greatly made work easier for everyone, but we also face some problems. In my opinion, the main drawback of such systems is that they are designed to make easier work of honest parties and arbitrators in civil litigation. However, it doesn't provide effective solution in the fight against delays and other forms of abuse of procedural rights. As I said before, the system of delivery of procedural documents in this case obtains particular importance. I think that in order to have effective system, we need to change our approach to the fact that executing the first service of procedural documents to the party, we must have proof that the party has actually received this document. Another important question is how much artificial intelligence can penetrate into the dispute resolution process. For example, is a fully digitized system of issuing court others already the limit or just the beginning of the process. I believe that today you will consider these and many other interesting and relevant issues. So I sincerely wish you everyone to have interesting and productive discussion and many new ideas. Once again, I would like to thank for the organizers for this excellent initiative. Thank you very much.
Hello, everyone. So I thank you, Vilnius University and Rimantas, for the invitation to coordinate this and moderate also this first panel. I don't want to take a lot of time, and I just go straight to introduce the first speaker, Dori Reiling, that is a friend of mine, and she's a retired judge, and also she has a PhD in IT. So I think she's the best candidate to start.
So it's yes, I'm a little smaller than that. Thank you so much for having me at this interesting conference. It's a great pleasure to be here. This is my first visit to Vilnius, and I'm pleasantly surprised by the winter. In Holland we have almost no winter anytime, so this is a real treat. And when we were discussing what I was going to talk about, Marco said to me, "You can talk about what you want." And I thought, what would be the most important problem to actually discuss here? It's very easy to talk about artificial intelligence because that's something that we can dream about it, but putting things in practice is much more difficult, as I have found out when I built systems for the Dutch judiciary. So I thought I should talk about the most difficult problem, because it's all very well to talk about AI, but to make dispute resolution a digital process is really hard work. So I'd like to talk about that and start with that. And it's not easy, but I can tell you it was a lot of fun. So my subject is the intractable problem of court information technology. And when we talk about IT for courts, of course, the first thing we have to ask ourselves is, what do courts actually do? And most people outside the courts have a fairly, let's say, superficial idea of what courts actually do. So I'll talk a little bit about what courts do, and then about what the consequences of those conclusions are for digital procedures, if you want to make procedures digital. And the last question is, how can we actually reform court procedures using information technology? So let's see, what do courts actually do? They process information. And they do that in civil cases, and in criminal cases, and in administrative cases. I have built a model that I'll just walk you through that explains how in the civil justice information passes through the courts, and why it does that in the way it does. There are actually two factors. This is a little abstract, but I'm sure with this audience here that will be no problem. So there are two factors that determine how information is processed in the courts. One is whether the outcome of a case, this is for the civil justice, is unpredictable. When it comes in, what comes in is a package of information. And you open the package and you think, oh, that goes that way. So that means that the outcome is fairly predictable based on the information you get. The outcome can also be extremely unpredictable. Oh, well, we need to have more information, and we need to talk about this, and before we know what the outcome can be. So that's one factor. The other factor is quite different, and that is the relationship between the parties. Do they exchange information, or do they withhold information from each other because they think that's strategically sound for them to do? And if they withhold information, that is the, where's my laser? Is there a laser on this thing?
Yes,
yeah. Yeah, here. Does that work? Yeah. This is where the parties exchange no information whatsoever, and here it is in their interest to do so. So this, in game theory, this would be a win-win kind of relationship, and this would be a zero-sum relationship. Well, having done this, I mapped cases on this grid to see what happens. So, the top left-hand corner, a predictable outcome, parties don't exchange information. For instance, money claims that are not defended. You know what's going to happen, that's going to be granted. So what happens here is actually title provision. And for the second group, the outcome is predictable, but the parties have exchanged information. This is what happens in most family cases and in a lot of labor cases, where the parties come with an arrangement that they have worked out for themselves, but they need judicial permission to actually make it legal. So there the court has a kind of a notarial role. The third group is a little more, already a little more difficult, because the case starts and things need to be done in order to make the outcome more predictable, collecting information, maybe having a hearing, but at some point in the process, the parties settle the case. So then the outcome of the case is the settlement. So they've cooperated enough to be able to settle the case. That leaves us with the last group. In unpredictable outcome, and parties are unable to settle their dispute. So that's group 4, and that is the group in which a judicial judgment is actually needed to make an end to the case. This is what we think of as what courts do, but courts do all those other things as well. Keep that in mind. So, if you are the CIO of the court system, you want to know how many cases are in each group to decide where to put your money using information technology. So, in Group 1 is 41% of the total caseload of the Dutch civil first instance justice. I did the maths over about a period of about 7 years, and this is 40%. 41. Group 2 is actually 36%. So then we've used up most of the caseload. Group 3 is about 12%, and it varies, but it's always a little more than Group 4, which is on average 11%. So of the total caseload, what we think of as what courts do is only 11% of the total caseload. Keep in mind. Okay, next question. Which IT are we using for each group? Because the processes are different, so they need different types of information technology. And in the first group, it's a large group, and we know the outcome, so we can automate parts of the process. E-filing for this large group is going to be really helpful, because it means that no one in the court still has to key in the personal information of the parties. Maybe we can automate some parts of the processing. And for this gathering, I've also added some maybe AI things. So maybe artificial intelligence can do some of the processing for us. Maybe. I don't know how, but maybe it can. For Group 2, all those things work. But maybe we could also use internet support, and I think we're mostly now doing that too, internet support to help the parties come up with an arrangement that is going to be legal. So information on the internet so they can do that. Group 3, everything else and negotiation tools. And that's actually what we were talking about in the workshop yesterday. Very interesting. I would really like to try and see if we could use that for this kind of situation. Group 4. So this is what we think of as what courts really do. And here, there is a lot of information. Things need to be done in order to make clear what the outcome can be. Large amounts of information, so digital case files can be very useful. And the judges also need knowledge systems to come to a conclusion. So this is the IT for each group. Whose phone is that? Now, my next slide is a little bit more down to earth. My experience has been, I'll show you how a system can work, but the world over, it turns out that implementing court IT is a lot like perfoam. How does that work? You know perfoam, it's insulation foam, and you spray it into a room, and as you keep spraying, it finds all the weak spots and all the leaks in your room. and it comes out there. This is what happens when you start implementing information technology. Always we underestimate the complexity of what we have to do. Even if we know we're underestimating the complexity, we just do not know when we begin how difficult and complex it's going to be. We're also, because we are human, overly optimistic about the results we're going to achieve. We're going to save a lot of money, life is going to be easier for everybody, and so we're overly optimistic about the results. We also underestimate the risks, like cost overruns or time overruns. It's very hard to imagine what that is going to be like when you start. So these are things that will always, they're inherent in IT projects, they will always happen. Court IT projects are politically complex. For instance, the systems that I built were in tandem with legislation, new legislation. So we were building and the legislator was making the legislation, and every time they changed their minds about the legislation, we had to redo our designs, which of course means time overrun, cost overrun. Governance, who decides what? If decision making about what needs to happen is divided over many different bodies, and I think the best example of this is the UK at the moment, where there are at least 5 bodies who have to decide between them how it's going to work. Governance is an issue. We also underestimate the amount of change that is needed in the organization. The kind of IT that we now have and that we can use can completely replace paper processes. But that means that we have to also completely rethink how we process that information. And that is a lot more complex than we can imagine before we start doing it. And the last one, your users. They are the most important people in the world if you're doing an IT project, but they are your friends because they have to tell you whether your IT is effective, but they are also your enemies because they always want about 10 times more than you can build for them. So those are the most important risks. They are all in my PhD that you can find on my website if you want. So knowing all this, what do you do if you want to do court IT? You make things as simple as you can. And there are basically 3 choices that you have. Reforming an existing process, that seems to be maybe the easiest way, but I'm not so sure about that. Replacing an existing process entirely, or designing a new process that may eventually replace a process, but maybe it's a completely new design. So doing this, I always look for examples to see where things have already worked. So let's look at that. The first choice is to reform an existing process in phases. And the first phase is e-filing. That's obvious for a lot of court systems, that's where they start. And all they do is e-filing, and what happens after the documents have been filed digitally doesn't really matter to the parties, and that's the court's problem. Phase 2 is to actually start reforming my Group 1 cases. It's because that is where we can do a lot of automation. Maybe we can even save some money. So that's where we can start. And this is actually what the Netherlands judiciary is, on second thought, doing at the moment. We'll see what happens there. Now, the second choice is to replace an existing process. And that is what we in the Dutch judiciary tried to do in the past 4 years. Replacing the civil procedure with a new procedure. And this is the simplest way to explain that. You know, civil procedures are complex. I'll walk you through this very quickly, and warn me if I'm running out of time, because this is going to take some time as well. This is the lawyer of this is a procedure for lawyers. This is the lawyer of the claiming party, and she files a case to the court. That's a new thing, because now you first have to go through a bailiff, but this is an innovation. The system, within about 10 seconds, has made a case file, has given the case a name, has uploaded the URL for the case file to the lawyer, so she has access to a case file in about 10 seconds after she has filed it. System has also made a control task for someone in the court to check whether the filing was complete, and the next thing is that the other party needs to be notified. Now, the easy choice would be, the simplest choice would be to have the court actually do that. But that was rejected by the Dutch courts, and so now the notification can be done directly by the lawyer to the party or through the bailiff. Here we have the bailiff, who can do a formal service, which is what you need if you want a default judgment. The defending party now has to find a lawyer, because only lawyers have access to our digital case files. So here's the lawyer who gets access to the case file and can then advise his client whether to file a defense. If not, the case becomes a default case. If so, then it goes, of course, then it goes to decision right away. But if they decide to file a defense, they can join the case, pay a court fee, and then they automatically get a term of maximum of 6 weeks to file a defense. And if they've done that, that means the case file is complete. All the time, after they have joined the case, there is a possibility for digital communication, uploading documents, and viewing the case file. So we have a complete case file. That means we now need to decide what the next step is going to be. That will usually be a hearing. So this is the legal team. They decide whether there's going to be a hearing or not. And they can communicate about that with the parties if necessary. Usually there will be a hearing. If there is no hearing, the case directly goes to the decision phase. Otherwise, there is a hearing, and at the end of the hearing, the choice is to the judge for the next step. If there is enough information, if the case is settled, it can be closed. If there is enough information, it can go to the decision phase. If there is not enough information, one of the parties is going to have to provide the information. You can arrange all that at the end of the hearing with the parties. Okay, thank you. And there will be another iteration. And once the decision is complete, it can be uploaded into the digital case file. Parties are notified. And we have seen this entire process actually being done in 7 weeks. So it can really speed cases up if that is what the parties want. Okay, this meant a number of improvements. More compliance with Article 6 of the European Convention on Human Rights. It's a lot simpler than it used to be. But I would like to also take you through my third choice, and that would be designing an entirely new process. And that is something that has been done in the UK. They have money claim online. That is basically, it's a one-trick pony. It can do only one thing, but it does that very well. And then there is, in British Columbia, the Civil Resolution Tribunal that was set up for tenant claims and is now expanding its competence to other areas. I think it's the best example of a new procedure using IT. Now let's see, what else do I have? I think this is about, So, what can we do to overcome all these difficulties that I've been talking about? One thing is that courts need to become more oriented towards innovation, which right now they are really not. IT needs to be integrated with where the courts, where the judiciary wants to go strategically. Having a process like the one I showed you means that the judge, it's the judge's process. It's not just a tool that you pick up and put back. It's your entire environment. So I think the judges need to take ownership of this procedure. We also need systematic knowledge development. People who have experience in developing these procedures should be used by the court system in order to further improve it. We have to look at usability of the system, and we have to also think about and communicate very clearly with stakeholders like the lawyers and everybody else. So these are things that we need to do, and this is my last question. What can you do? Thank you.
e-codex. Please.
All right. Good morning, everybody. Thank you for the invitation to speak here at this interesting conference. I will talk today about cross-border digital data exchange and specifically about e-codex and improving the access to cross-border justice. First, I will introduce e-codex as a solution for cross-border digital data exchange and then talk about the connection with access to justice. I work at the Ministry of Justice in the Netherlands, and the Ministry of Justice is one of the partners in the consortium that is currently maintaining e-codex as a system. A little bit further in the presentation, I will talk about how currently e-codex is maintained by a number of member states, but we will transfer that responsibility to an EU agency. But let's just first talk about e-codex. So e-codex is basically about the transmission of case-related data and documents in the legal domain, cross-border, so exchanging information between member states. And this is specifically related to different European procedures in which data exchange between member states is necessary. For instance, the European Payment Order or the European Investigation Order. Here you can see e-codex at a glance. So first of all, e-codex supports overcoming legal boundaries, making Europeans feel safer and legally protected. So actually, the claim of e-codex is that it should not only be easy to get access to justice within your own member states, but it should be as easy to get justice across borders. E-codex provides easy access to cross-border justice for citizens, for businesses and legal professionals in Europe. So making it easy to exchange information between those member states makes it easy for all these parties. And we're using a European digital infrastructure for secure cross-border communication in the field of justice. Well, let me just shortly introduce how it works. This is the technical infrastructure of of e-codex. So basically what it is that e-codex provides the interconnection between national systems within the member states. One of the most important presumptions of e-codex is that the systems within the member states can stay the same and that e-codex is a way of connecting those systems to each other without changing the system within the member states themselves. So investments that have been made in the member states can still stay the same, and e-codex is only about connecting those systems to each other. So how does e-codex do that? Well, we provide actually two software components which makes the exchange possible. First, we have the gateway, it's the G in the picture, and we also have the connector. So what is the difference? Well, the gateway is actually just a sort of highway which provides the secure connection and exchange between messages between the member states. And then we have the connector, which should also be installed within the member states, and that's actually the part of the system that makes the adaptation, that makes it able to connect it to the back-end solutions in the member state. So we have the gateway that's actually exchanging messages, and the connector, which is the intelligence of e-codex, making it possible to adapt, to make the necessary adaptations to make sure that the message can be read by the national back-end solutions in the member states. And one of the most important components of e-codex is that it provides semantic interoperability. So it provides a layer that makes sure that a specific term, a specific type of structured data can be translated in order to be read by a system in the member state. So for instance, a citizen who needs to file a document for European Payment Order can actually just file the claim in its own languages, send it via e-codex, and through translation it can be read in the member state in the language of that specific country. Well, in 2010, the eCodex project has started, and actually it already ended in 2016. Currently, we are in the state of maintaining and the systems, and also to show legal professionals and member states the advantages of the system. For now, the feasibility of the technical solution has been proven. Now it is just about the uptake of eCodex in the different member states. However, we see different problems occurring along the way, and those are not related to technical problems, but more about legal issues. So that's why the focus has shifted from IT topics to legislation, and it moves onward to legal professionals. As I said before, currently the system is maintained by a consortium of member states. However, it is foreseen that in 2022, the handover of the system for long-term maintenance will be done to an EU agency, which will probably be EU LISA. And in the upcoming years, we really want to expand the use of the system and also show the added value to the academic community and also to the legal professionals who work in e-justice. Okay, let me move a little bit to the topic of access to justice and the problems that we have encountered within the eCodex projects. So first of all, we within the project, we work with legislative experts, but also with IT experts. And what we see that actually at the core, they both have the same goal. So they want legal protection for the citizens. However, if they need to work together, you see that IT experts and legislative experts both have a very different focus. And it's within eCodex, we have seen that it is hard to let them work together and to see, to show them how they can actually be a strength to each other's work. So IT experts are mainly focused on, for instance, UX design, so which is about the user interaction. So for instance, if you're designing a form for a specific procedure, IT experts work on how that specific form is designed, and also how they can really have added value to show how user interaction takes place. So how users actually, what they experience when they have to fill in a form. We also call that the customer journey. So see how citizens actually go to the journey of filling in a certain form. And they have specific knowledge about the reuse of existing software. So the IT experts are really focusing on how should those forms look like, which need to be exchanged via eCodex. Then we have the legislative experts who have a totally different focus. They focus on subsidiarity, the legal tradition, the liability, other concerns that are related to EU legal procedures. Our ultimate goal is to simplify access to cross-border justice. Currently, as we have also heard before, access to justice, and especially cross-border justice, is at stake, and we are in need of a user-centric approach. Well, currently, the eCodex infrastructure is in place, and there are different services that can be connected to the eCodex infrastructure. So, for instance, there is a court database in which you can look up the different competent courts for specific procedures. Well, this court database can be connected to eCodex. So via eCodex, you can see which courts are competent for a certain legal procedure. Now that the eCodex infrastructure is ready and different services are connected to eCodex, we really want to progress and want to invite third parties to build applications that use the existing eCodex infrastructure, so the infrastructure that makes sure that messages are exchanged securely electronically, and also the services that are already connected to eCodex. So for instance, a court database. So if we can open up the eCodex infrastructure and also the services that make use of the eCodex infrastructure via APIs, it can actually really boost innovation and boost cross-border justice. This is also true for online dispute resolution. And one of the problems that we see when we focus on making cross-border justice viable is that at this moment there's a non-existent escalating procedure. So what we see is that the different procedures that are in place are not connected to each other. And for citizens this is quite difficult. So for instance, if they have a conflict, they have the opportunity to go to a web shop, for instance, Amazon or eBay, to go there for their dispute to be resolved. There's also online dispute resolution, and there are also different European procedures, so just like the European procedure for payment order or the European small claims procedure. However, those procedures are not interconnected. So if we really want to focus on simplified access to cross-border justice from an electronic and digital perspective, we can interconnect those services. So it will be easier for citizens when they file a form, when they file a complaint, that they have an escalation procedure which is connected electronically. So to round it up, eCodex stands for the advantages of cross-border justice and making it viable to exchange message cross-borderly, to make it easy for citizens, for legal professionals and businesses to get justice across borders as easily as they can get it within their own borders. Thank you.
Thank you so much, Sandra. So he's a founder of ODR training. You can see also a leaflet in your papers. And please, Graham.
Thank you. And real pleasure to be with you. And coming from the UK, I'm spelling that EU. I learned something about Vilnius. My first time here in the country and in Vilnius, but I learned something amazing only a week ago. I knew my grandfather was born down in the deep south of Russia in Rostov-on-Don, and I was just getting some old papers and an article to talk to my grandson about him. And it said he was educated in Vilna. So I'm now going to spend a few days trying to find out, was it here? I don't know. He left at a very early age. Anyway, let me begin with a fact. 78% of businesses here are breaking the law. It's a law that Merez has mentioned, one or two others, and I'll go into a little more detail to explain. I'm not having a go at Lithuanian businesses or the law here, because in the UK, we're worse. We're 86%. But look, and I'll explain about all that. Now, can I just ask you a question? Hands up, all of you here who on a regular basis tell lies. One. Well done, sir. And madam? Well, the rest of you are telling one right now. How do I press this? Anyone familiar with this? We're always saying we've read and we understand. I get about 50 screens on my iPhone whenever Apple want to update it and get me to agree. So that is the case. And look, let me. This isn't working. The actual truth is, as I'll explain, because of that question about terms and conditions, it's 100%. Now, I'm going to talk to this catchy title of the algorithmisation of dispute resolution, but I'm also just want to say a few things more generally, as colleagues have, about ODR itself. One thing it's important, a lot of people who say, oh, well, I'm involved in ODR, and we do ODR, and we offer ODR, and they use it as it was initially, as merely a platform for communication. So if you're mediating, you don't necessarily have to be in the same room. But it's now developing much more into the online applying to the resolution. Tools that actually help the parties to be more likely to resolve their dispute than if they didn't have it. It's these tools, and I'm going to mention and show something on that respect. So it's much more than conferencing. It's blind bidding, which I'll go and show you some examples of. Automated case framing, so case filing systems that actually help the parties to frame their cases better. You know, the worst thing is to give people a blank piece of paper or a blank box online and say, what's your case about? Particularly if they're not represented, as is happening in the UK, more and more litigants in person, which are taking up too much time in the courts. And we need to be able to assist people who haven't got lawyers to at least be able to frame their case better, and the other party can respond more directly. Tools to do that are very important and are developing, and analysing cases and learning knowledge, learning systems that can, once thousands of cases have been entered into, can help recommend outcomes and suggestions based on the past. And that's being developed. And also game theory to aid prioritization of issues. When people, let's say, in dividing property after a divorce, and they're asked what they want, they often spend as much time trying to deny the other party through their anger as to seek what they want for themselves. But you can use game theory, and there is somebody, John Zalesnikov, in the University of Victoria in Australia, who's developed systems that work very well in that respect. These are all the things that ODR, more specifically as a tool, can do beyond merely email, web conferencing, and all that. Important though that is, for any mediators here, obviously online is important, and it surprised me that there is certainly a slow pickup from mediators that using various online mediation platforms or just using the internet to mediate, because of course it would massively extend your marketplace beyond disputes between people who can actually get around the same table with you. Where there's language and cultural divide, you could have dual mediators working online. Where there's a negative interrelationship, where I deal with shareholder disputes, much like divorce. People that invested their lives with this other person or persons in running this business. It hasn't gone as to plan, and there's a lot of anger, and they often they relate to each other in their presence in a certain structured and negative way. Going online can help the mediator to remove them out of that. Obviously, where we've heard a lot about low-value disputes, which might not otherwise justify the cost of in-person mediation, it can help there. And urgent cases. So I don't know if there's a ship being locked out at sea and being prevented from getting into port. You may need to mediate like now, like within the hour. And obviously you need online facilities to be able to do that. So there's lots of ways, if you're a mediator, where you need to look at what is happening as something that is good for your practice and its future. Now, let me try and come more specifically into the subject of this fascinating conference today. I'm showing you here a screenshot. It's actually made up of two screens from a system called Smart Settle 1 in fact, which is what they call a visible blind bidding tool. That may sound a bit of a contradiction if it's either visible or it's blind. Well, what you're showing is a slider which the parties use and on which they can both present an offer where the dispute is purely about money that the other party sees, but also present, which is the yellow offer, that the other party doesn't see. And the algorithms behind this, of course, see everything. And various rules can be set in place as to how close at any stage the secret bids can be to declare a settlement somewhere within that gap. Obviously, if both bids at any stage overlap, then that's a true win-win, wherever you set the settlement between those figures, because the person who's paying is actually ending up paying less than he was prepared to on his bottom line, and the person receiving gets a little bit more than what he was preferred to. It doesn't just, this is available, and it doesn't just split the difference, as a system that I developed some years ago did. What it does is it understands what effort each side makes using their bids to settle, and the algorithm rewards the party that makes more effort. So it doesn't just hit that midpoint, and that's the case also where they overlap. So you know that when people negotiate, whether it's to resolve a dispute or maybe just to buy something, they try to keep their bottom lines secret. They might offer 10,000 euros. They may be prepared to go to 12,000, but they want to get the impression that is my final figure. That's natural. And in negotiation of dispute resolution on the money, where you're a lawyer negotiating for clients, you have to be very careful about your negotiating policy and stance. And all that takes time. It delays things. So a system like this can actually cut through that instantly and enable people to make use of their bottom lines without giving away their negotiating position if no settlement is actually reached. Now, a more complicated version of Smart Settle, this is of something called Infinity, which is actually looking at a dispute where there may be various elements and trying to gauge to help the parties identify their priorities in this regard. So this may be a bit complicated, but let me try. Have I got a little pointer here?
Yes.
Which
laser.
one? The laser is. Try not to point it at anybody. The side one.
No.
Ah, okay. So on this side, I designed this with them for a typical business-to-business dispute. So you've got a manufacturer supplying a wholesaler who supplies a retailer. And there may be some goods that they buy a parcel of these goods every month. And they pay every month. But one month, they don't pay. Maybe they're having some financial difficulties. It may be there's an actual reason for a dispute. Maybe the products were a bit late this month and gave the buyer some problems. But they've been doing business for some time. And as a mediator, we know that if we're being asked to mediate those cases, we go a bit further than a court would. A court can only decide whether that payment for that month's goods should be paid or not. Can't do any more than that. But as a mediator, you would say to the seller, having found out why he feels the money should be paid and having found out from the buyer why the money should not be paid, you might ask the seller, well, how much money have you made from this customer over the last year, 2 years, 3 years? And are you then prepared to lose that sort of money in future? Because even if you win your case, it may well be that because you've sued your customer, he might understandably go and buy his items from somebody else. So you might lose a lot of the future continuity of business. That's an important part in business. So we're trying to divide this type of typical dispute into other elements. So you see that this element, there's 5 issues here. Further trade compared to the last 12 months. How important is it to both sides that they continue to do business? The buyer, it may be important because he may not more easily be able to buy goods from somebody else, but he feels a bit angry that he's been sued. The obvious first issue is how much is paid to the seller. And then there's the question of an online review, not just in consumer sales, but in B2B, people will, in certain communities, business communities, might want to post reviews and comments. And we know that's increasingly an important issue in maintaining trade and one's status. There may be a bad review that the buyer had posted about this seller. Is it valuable to the seller to have it retracted or maybe changed to a positive one or a neutral one? Can there be some services in kind that either the buyer can offer or the seller? Maybe the buyer, I don't know, is a technologist, web developer, can do something to improve the website of this. I don't know. All the sort of things people might want to gauge. Now, what happens is, so with Infinity, you build this model, the first thing you do, and you decide what the various items to be discussed are. And then each party presents a series of values. The party says how much each issue is important. There's another screen which I won't show, but which is used to assess the level of importance that each of these elements is to the party. And then the party will make an offer. Here, these blue ones here are called the optimistic. You start off by making a range of offers, and the system evaluates them based on your level of importance and priority. The ones ticked, this blue one and this red one, which is a very low one, is the ones that are showed at a time. Now, at any time, you can publish, you can share your set of proposals, how much you pay, whether you do future trade, what you're going to do about the review that's online, and you might share them. The system, if you can then accept one that the other sides presented. If you don't, the system can make suggestions knowing what each person's interests really are. So that's infinity. So that's where there is some practical work in, as I said at the beginning, using technology to help bring the parties to a resolution in a way that would not be so easy without looking for the... No, I've got to point it here. Can I just... Okay, now here's an interesting one. I better wrap up. We had a conference in Liverpool I organised early in the year, and we actually used that system to try and settle Brexit. Do you know what? We did it in 2 hours flat. There's a video, people. We had Diana Wallace, who's been a vice president of the European Parliament for 5 years. We had somebody who knows about the European Parliament. There we go. There's a screenshot of what we were doing on the day at this festival. Each of the lines, it's the same as what you saw, but with a lot more lines involved. The land border in Ireland is in the issues about customs, the payments and everything. And they did. It's quite similar because we were using artificial intelligence, not political intelligence, in inverted commas. And another important point is because we had to work out all the issues that could apply, the Northern Ireland border, which nobody talked about at the time of the referendum, would have been in there at the earliest. The worst thing in any negotiation is thinking you've got an agreement by agreeing, and then another issue is raised by one of the parties and disrupts the whole resolution. Something like this. It encourages you to get it out at right at the beginning. So I said 78% are breaking the law. In fact, and this is the law, of course, we've heard about the regulation on ODR, that requires everybody to put a link to the European Commission's website that will redirect people to an approved ADR provider. To be approved, they have to operate online. So essentially, I got very excited about this law because it essentially made businesses would have to promote, if you like, ODR. It would have to help unhappy customers find ADR organizations that operate online, and that would be good for ODR and people beginning to experience it. A couple of years, the year before last, they produced a report, web scraping report. They sent some little things out to trawl through the web and look and see whether retailers were complying with the law. And this is what they found. That's Lithuania, and on the right you'll see 22%. In other words, of the sample of 169 companies' website, they found only 22% were complying. The UK's down here, we were only 14%. Now, and that's terrible. We've got this law in place that's going to supposedly to help the single market work better, because people were still not buying cross-border within the European Union as intended by the single market. It's confidence, it's trust. And here we have a system to enable that. That was what the whole purpose of the legislation was. And they're not doing it. And I think the actual compliance level is less because, well, first of all, the total numbers show it's not working. There was a report said, in each month, the numbers of people submitting claims to the portal was rising. So if you take the last month, February 2017, there were 3,714 claims, which sounds a lot. Wow, that's a lot of claims to look at. Hang on, the population of the EU is 500 million, 500 million. So that works out, one person out of every 135,000 submitted a complaint during February 2017. Does that sound as if it's working? One person. And what does that look like, one person in 135,000? Well, that's 13,500 singing Hey Jude in Trafalgar Square. So let's multiply that by 10. And imagine there's just that one person, and the second from the bottom is the only person in the whole of February 2017 to pursue it. It's not working as it should. So there we are. That's a thought to leave you with. A word from our sponsor, which is me. No, I'm not really sponsored. You've got a leaflet if you want to know more about it. We have a training course. And like a carpet salesman, I'm crazily giving you a special code. If anybody wants to take the course, L1285, which is an adaptation of liters, you get 50% off. I must be mad, as they say, in the carpet world. So there you are. See you at a court. Thank you very much.
Thank you so much, Graham. And so we can now finish this marvelous panel with also two friends and colleagues, but also co-organizer of this conference, so with Milda and Rimantas. Thank you.
I'm sorry, but who left the phone here? It's ringing.
What's that? Oh, is that my phone? I'm hopeless with
So, dear colleagues, it's both...
oh, it's time again.
Yeah, sorry. Dear colleagues, it's both a pleasure seeing that many of you today here, and also it's an honor of being able to discuss with you the question and the issue of algorithmization of dispute resolution. My name is Milda Markevičiūtė. I'm a researcher and PhD student of Vilnius University, and together with Associate Professor Rimantas Simaitis, we're going to present you an issue regarding efficiency and legitimacy and usability of modern methods, which is a very complicated topic, but the issue is, will it change the current situation which we are having right now? We will also present you a project that we are working on. It's called CREA, conflict resolution using quantitative algorithms, which means that we're working of algorithmization of disputes next to being litigation lawyers. I'm going to introduce you the project, and then I'm quite sure of that Rimantas will steal the show. Why this topic? IT and modern technologies change fundamentally the lives we live nowadays, and the biggest credit should go to, of course, IT and the internet itself. Although some spheres are quite adaptable to changes, like let's look for a few past years, what's happening with fintech, law field is quite conservative. And we're raising an issue that, and in this project we're raising an issue that dispute resolution, at least dispute regarding division of assets resolution, can be modernized and can be algorithmized. Now, why this particular group of disputes? Imagine how, well, for me at least, it would be how nice it would be that instead of having 10 rounds of negotiations in some kind of case regarding divorce or regarding inheritance, instead of these 10 nasty rounds of negotiations, which usually is nowhere near regarding on the division of assets, but instead of that we could input the data into the algorithm, and in some time we would have a solution, a proposed solution, which would be fair and which would be envy-free and which would satisfy all the parties in the dispute. These criteria has been developed and analyzed in various fields of law, for example, in economics, in psychology, and in mathematics, in game theory. However, it wasn't analyzed in law. The thing is that parties to the dispute usually feel satisfied about the outcome when the outcome is all of these criteria, when it's fair and it's maximizing of utilities and it's free of envy, user satisfaction, when it's sufficiently speedy, and when it's used and when it's reached using proper methods. So these criteria were not analyzed quite properly in law, and now we would like to analyze a little bit about whether the existing legal tools allows us to reach a solution which is all of that. And this is where CREA comes in, our project that we mentioned. It's conflict resolution with equitative algorithms. The project is co-funded by the European Union. It involves 8 European Union countries, 7 universities, and 4 partners. And the main aim of the project is to introduce a new mechanisms which would help to solve disputes, which would give a tool in legal procedure for lawyers and mediators and judges in order to help them to find friendly solution either in court or out of court. And this tool could also be used directly by the citizens. The activities that are being developed is application of the existing equitative algorithms, also development of new algorithms, trying to analyze what applicable rights there are in each EU country participating in the project and what is the mandatory rules. Then developing a common European ground, what is common between those countries, and adapting algorithms and developing a software that would enable us to reach a solution which would be all those criteria that I told you. Fair and envy-free and quite speedy. And we expect that the timeline, the project started in November 2017, it should last until November 2019 with a consortium's view to develop results further on. We expect to have a working algorithm in May 2019, so I hope we could present you some valid results of how we imagine this algorithm could work in the 2 fields that we picked. And currently we're picking exactly 2 fields that are very sensitive. It's divorce, division of assets during divorce, and also division of assets during inheritance. Currently we have some interim results. So, as I mentioned, these 2 sectors have already been selected. We have also done an inventory of what algorithms does exist. Unfortunately, there are some, but they are not very well analyzed. We also have done a comparative analysis of mandatory rules in the 8 EU countries, and we're developing 2 new algorithms. And as I mentioned, we hope that it could be used in negotiations, in mediation, and also maybe even in litigation, depending on the mandatory rules that we'll see. So since we are 30 minutes ahead of our time, I will give the floor to Rimantas, who is going to...
Thank you, Milda. And in continuing of the topic and presentation of our work, as Milda has already given you information, we are focusing on very narrow sector and very narrow sphere. Why? Because you cannot, well, take the broad sphere and broad sector and reform it or revolutionize it. No, that's not possible. That's not possible. If you are going to take this approach, it's going to fail. So what we are doing in the project, we are narrowing our focus to 2 disputes, 2 types of disputes, or maybe 3. Currently, it's 2 types of disputes. And first of all, what we've tried to do, we've tried to inventorize what algorithms are already in place, what might be used for these disputes, but the design of new algorithms shall take place. And yes, the answer, yes, it shall take place. And for your knowledge, for your understanding, there are more than, well, 10, 20 algorithms which are available, which are in place, which might be used. It might be put in the system, and John Železnikov from Australia already have done that in Australian framework and market, and there are systems, already online systems, which you can as well use, or maybe which you can try to use to look how they look like. They are online, available, they're achievable online, you can read, etc. Still, they are not existing in our markets, in European Union markets, and there are certain problems connected with legalization of these issues. And so what we're trying to do, we're trying to adapt, well, this know-how, this mentality from different fields than the legal field, and bring it to legal existence, legal realm of European Union, which might be possible to apply in these fields. First of all, negotiation, mediation, and maybe litigation if we will be successful in application of that method, and if we would be able to convince judges and to integrate into litigation proceedings. One of the steps of application of up-to-date, using advancements of all the sciences which were listed, including behavioral economics, including mathematics, informatics, game theory, heuristics, and all other sciences, and leading to all the criteria Milda have started with, and giving a tool for judge, mediator, and negotiator, maybe party, in the proceedings, to reach all these benefits, all these goods, which were listed and currently which were not achieved by application of classical legal means. Yes, that's fancy, that's good. If we will be able to design, and most probably we will design certain tools which might lead to achievement of such beneficial results, there would be a question. Who is going to use this and why? So we'll be able to design a system which would be user-friendly, which will be usable and producing legal results, legalistic results, which will be efficient and nice to use, which will be producing all these results we have started with. Fairness, Pareto optimum, efficiency, yes, user satisfaction. For us lawyers, being majority in the room, it's very important. Will these systems will provide legitimacy is substantial law, things, and procedural style. And the final one, will these systems be recognized by those people who are, in fact, crowding the litigation system and applied by them, as well by users? And they will be reliable or not. I will tell you that all these issues, all these dilemmas are really existent, and in our work of R&D and research and development, we already noticed, we already run into many problems, and all these problems are affecting the whole designing of the structure of algorithms, and the way we think that these algorithms might be integrated into existing proceedings, existing systems, and existent substantial legal framework. There might be a need even to change our laws in order to enable these algorithms, which we will design and we are already in place, to be applied in practice for the benefit of users and lawyers. And we already noted that differences, even between European Union countries, being a single market, in these two fields, in mandatory rule senses, are quite substantial. They are not unified, they are not harmonized. When our economical teams try to look at these differences and try to extract, and we with legal team, we are helping them to extract the realm where these algorithms might work, they say that we see quite substantial differences in mandatory rules, which we take care of in order to build up something matching to this criteria, legitimacy criteria, and that's a problem. Because these algorithms shall be friendly to law, to legal environment. Already one of the speakers gave you a question opening the speech. I will give you the same question, a short quiz. See, two options, two potential, well, one potential judge, another existing judge, human judge, and judge a machine, a robot, or artificial intelligence tool, or algorithm. In broader sense, algorithm. You can call this artificial intelligence well, phenomena, one of the sorts of this well, broader concept of algorithm. So the question for you, and I will ask to raise your hands, whom will you trust the more? Who would be of these two the most trustworthy? So the first option, human judge, whom you do believe more currently? Human, okay. What about this phenomena? Anyone? Awesome. Okay. Awesome.
The claim dispute we have in which jurisdiction? It depends a lot. If in Russia...
Yes. Very good notion. And I see in this audience very flexible, broad-minded people. Yes. Well, I just voted for this one because I know how underdeveloped currently these are. In the future, my vote might be different. And you rightly ask the question, where, in what jurisdiction, that is also very interesting. Still, in Russia, this as well cannot provide you trustful result now, but in the future, the situation might change, yes. And if we will develop these phenomena, because all the big things, all the bonfires start with sparkle, yes? So currently we are talking about a project, we're developing a project which might be a sparkle to lead further on to development of this type of phenomena, integrating into ODR system, even integrating into traditional judicial mediation systems, which we use currently. And maybe then the vote might be a bit different when majority will shift to this side. By the way, we have a scientific research of interaction of humans with computers, with systems which already work, still we are not with these well, automated systems. But these research were more provided to systems of trading in securities where artificial intelligence tools are more developed. So these research show that humans tend to behave less aggressive, less manipulative when they trade knowing that then on the other end we have an artificial intelligence robot trading with them instead of humans. When we try to make things, businesses trade with some well features of potential manipulation against humans, they used to be more manipulative. So that's the same. If you go to court or to some system of settling your dispute with professionals, with lawyers, assistants, etc., and you try to reach the most beneficial result to yourself, yes, you may try to engage some activities of, well, trying to receive a better result than well, its fair result in according to the books, etc., try to be more manipulative, yes? So this research confirmed that if you would go and knowing that on the other hand, you have this phenomena, not human phenomena, most probably level of manipulation, level of, well, emotions expressed in front of these, well, phenomena will be lower, much lower than currently everybody is exposing, litigating, arguing in front of judge, in front of human judge. Not worth it to say, this does not lead us to the conclusion that if we will be able to develop with so small sparkles, we're already discussing about this project. Graham told about his initiatives. He is one of the best known developers in the world of ODR systems, and he knows that you need to design lots of systems. Some of them are efficient and popular and usable. Many of them are not. So if we will be able even to design, and most probably we are going to this direction, we will design, will be another very important question: how to make these systems popular, operable. Okay, this is in theory. Maybe we will trust these systems for more later on. Currently, some of systems might be trusted because we are quite simple. Some of them might be used already, but people do not know about this. These blind bidding systems were already in place. Many other systems which might you use where on the internet you do not know, you even do not refer to them, notwithstanding that European Union regulations and national legislations oblige businessmen to do that, and we saw that everybody is disregarding this rule. So what's going on, yes? Why we have such a huge problem of breaches of law? And I think what we'll try to discuss a little bit and debate a little bit with Milde, with you together now, is that the gatekeepers of this case, there might be users, but most probably not. Most probably, as we see other innovations trying to go through the wall in this dispute resolution sectors, we're always facing the same trouble, the same resistance, the same obstacles connected with legal professionals. Legal professionals are true gatekeepers, which is, who can tell you are not going to pass in my domain. Why? Because they're dominant here. It's their business. No one shall go through them if they will not verify them. And they're judges, notaries, attorneys, lawyers. So you have to make systems which will be not only user-friendly, but lawyers-friendly, professionals-friendly as well. And you need to convince them that these systems will help them in doing business, in earning money. For judges in doing their day-to-day judicial activities or judiciation activities, they will be for their ease of life. And as well, we will not steal jobs from them in the future. That's very important as well. Because we lawyers, and especially acting in dispute resolution field, where normally trained in our mentality is looking backwards. We are very conservative. We're deciding about the past using past rules, and normally we do not take care about what's going to happen in the future. Judges take decisions about past. Yes, maybe a very small portion of their mind, they think, okay, I will issue that decision, so what effects it will make on the parties? Doesn't matter, because no one asked me to take care about the future. That's what mediation does, yes? Judges do not do that. And that's also very important to understand how to go through these gates. You need to convince them that on these basis of new algorithms, they can survive, they can make their business, and these algorithms or these systems can make their life better. As lawyers, professional life, not stealing money. Another thing, if we will not be convinced enough, and most probably that would be difficult to convince enough from the very beginning, they are very sensible to legal imposed obligations, and most probably the way through of potential boost of this algorithmisation of dispute resolution is nothing else but just simply integrating them into existing system and telling to lawyers, to users, you have to use it. If there are certain serious obstacles of, generating good results or usable results, okay, you can opt out. Currently, we are in a phase that you have to opt in, not opt out. And if we're going to leave it as it is, I mean opt-in systems, most probably usability of them and efficiency of them will be quite low. One of the example, we with several colleagues in the room have been developing and have been implementing e-filing system in Lithuania in 2012-2013. It is called e-justice portal, elektroninių paslaugų portalas, teismų. Electronic portal for justice system, which enabled e-filing in Lithuania case management system in 2012-2013. From the very beginning, and we had this expectation that there is a huge resistance by lawyers, by judges, by all other people, even some of them are sitting in the room telling we are not going to use them in decades. This is not for us. We're used for our paper files, which is more convenient. Clients like it, we use it, and, get off. We are not going to do that. When it was legal obligation imposed on the lawyers and judges, you have to use it. Digital case file is a right of a Lithuanian litigant. Come on. We have in the law said that. It is a right for everybody to have access to digital file, and that's right of litigant, of a person, when you go to Lithuanian courts to have it digitalized. It was, told by our legislator only then, after 1 and 2 or 2 years after application in practice, majority of lawyers, including judges, and complaining about that the system was too user-friendly to attorneys, to lawyers, and not user-friendly to judges, they realized that they cannot live without that system. And they cannot imagine their life if the system gets shut down for 15 minutes. So that's a national tragedy for lawyers. That works. But in order to reach that result, what you need to do? You need to impose legal obligations for them and say, let's use it. We do not care that you do not like it. We do not care that maybe it takes some business from you, etc., etc. You should learn how to do business with it in different manner, and you should educate yourself. And after that, now we have almost 80% of the filing so Lithuanian courts made electronically, and even larger percent of civil administrative cases operated digitally and kept digitally. Still not 100, but that's existent. Few last notions regarding this subject, this topic. We have to have in mind that too optimistic approach towards developing of a system, integrating them, might lead to very negative consequences. That's why international organizations, including Council of Europe, they take quite precautious approach. They even issue documents, there has been document a few years ago issued by the European Parliament regarding robotization of various sectors of life. Still, it was not very concentrated on justice delivery systems and justice systems. But there has been a document adopted by CEPEJ, European Commission for Efficiency of Justice, in December of last year, just fresh document, which on the basis of scientific studies, and some of the people sitting in the room have conducted, had added up to conducting these scientific studies, they extracted and they approved 5 main principles for use of algorithmic systems, more sophisticated algorithm systems, artificial intelligence systems, and artificial intelligence in judicial sector. And here I would like to point you out, well, Council of Europe, and there is the Commission of the Council of Europe, they're always concerned about these aspects, yes? So these are fundamental rights aspects, and non-discriminating one of them, because scientific studies showed that artificial intelligence tend to discriminate, and that's the reality. They tend to discriminate, and some artificial intelligence, very sophisticated systems with lots of investment had to be shut down. For example, employment selection system had to be shut down because they're discriminatory currently. And that's why one of the fundamental rights was specifically mentioned in that particular ethical code. 3 other principles are also very important: quality, security, transparency. Partiality, fairness, we also discussed that topics, and this one, which means users have to control them. Not the systems have to control users, but users have to control and have to be conscious about what system is he or she using and how to use it, including lawyers, including final users, beneficiaries of that system, with the meaning that even the final vote, or this one, I'm getting a little, would be that we like new phenomena, maybe in 5 years, maybe in 10 years. Ethical charter says, but we should be cautious about this, and the final user to operate the system, to control and to say final word if anybody is unhappy. For example, lawyer of one of the parties is unhappy about the final result, etc., and they have not subscribed to the recognition of the final result. Somebody like this has to review this result and has the power to say, no, I do not like it. And that's how we would be able to convince lawyers, judges, to pass it through, to let them go in this route, yes, and most probably to allow the system, piece by piece, step by step, go forward with rule, and helping us as lawyers, and helping users, our clients, notwithstanding our judge, notary, attorney, or other lawyer, to reach for these benefit of these criteria we started with Milda, our presentation. And what's the way forward? Very, well, few comments or few suggestions. Well, creation of usable, efficient algorithms of software tools, that's for sure. That's what has been, has to be done. And Graham is on that path. We are the CREA team is on that path. Jean Železnikov is doing that in Australia. Smart settled, cyber settled, eBay systems, we're all doing that, yes? And many of them are very efficient, very usable, and using algorithms as well. For the legal system, for the legal professionals to recognize it, you have to create user-friendly and lawyer-friendly systems. You have to take into consideration that aspect. User designing of the systems, meaning only final beneficiary, is not enough. You have to design the systems with a notion that lawyer as well will be one of the beneficiaries, keeping the gates of the popularity and efficiency of the system. And Another thing, in order to enabling this, you have to create environment to integrate everything into the existing mechanisms of dispute resolution in legal field. We had very extensive discussion yesterday in a smaller team of CREA and some external experts that, okay, we maybe would be able to design something, well, wonderful. But wait a minute, that's not enough. That's not enough to reach the final result. We can design it, put it into drawer, and be happy with it. No. You have to integrate, and the huge realm of variety of facets then opens up, and the huge realm of issues goes forward. And the last notion as well, very important, in our, that's very core, that's very basis. Currently, in designing and promulgating a law, what we're doing, we are creating ambiguous, abstract laws, and all the lawmaking proceedings, we are not sufficient enough for the algorithmisation and using IE. One of the issue, if you read any part of the law, most probably it might be interpreted by, well, 2 lawyers in 5 different meanings. And we know that phenomenon. Wait a minute. If you try to automatize it and to give to the computer, read the law in solution of a dispute, it shall provide only 1 meaning. So what's the issue? What's the problem? And we lawyers tell that provision of different interpretations, selections for all these 3 meanings is correct because human lawyer will do that, and we're all be happy with that because he will do that fair, and that will be the law, yes? So current system is not designed in that way, current legal system is not prepared that these digitalized law, algorithmized law systems will sufficiently and efficiently work. And has been work already started. Try to design laws, try to redesign lawmaking in such a manner that computer and human would be able to read the same paragraph of a law in the same manner with 1 meaning, single meaning, no ambiguities. And that's also the move forward. And by the way, this is very basic cell, how to enable further algorithmization of law. So redesigning substantial law and all the proceedings what is making. And by the way, if anybody thinks that that's an easy task, well, no problem. I would say it's a huge task, and lots of people, not only politicians, lawyers, would have lots of work to do with this. Also psychologists, mathematicians, sociologists, while politicians, and vast majority of other quality professionals would be looking at this subject, and we have already started to do that, and you will hear after the lunch one of the presentations about what are the first steps is made here at Vilnius University about this. Thank you for your time, thank you for your presentations.
Thank you so much, Rimantas. So, just to be brief, I just now put the spotlight on you all. If you have any question to one of the members of our panel. Yes. Rimantas, we have microphones, or they can...
Yes, there shall be mics available.
There is one guy in the back.
Yes. Can you hear me okay? No, we will give you a mic.
Thank you. So, Simas Tatoris, I manage a portfolio of diagnostics for a large pharma. So a bit of an odd profile here. I have a question for Mr. Ross. So you mentioned that there's an AI system behind your ODR platform trying to slowly nudge the participants to some sort of common agreement. So the question is really, how do you design an objective for this AI that is fair? And how do you then optimize the behavior that's the right behavior so that AI does not form a bias or, you know, it doesn't cheat? How do you do that?
Don't know. No, well, let me clarify, because that's not the work that I'm, as a lawyer, particularly on the technical side of nudging. What I can say is the reference to nudging is that, for example, using what I understand about the smart settle system, firstly, on blind bidding, knowing that the other party has made a movement or is not making a movement may have some impact, given that the parties are separate. On the infinity, the more complex one that I was showing very briefly, the system can sometimes come up with well, parties can come up with suggestions, or the system can come up with suggestions, but whether the parties do or the systems, it's still called suggestions, and the other party doesn't know if the package of proposals has come from the other party or has been suggested as being useful by the technology. I think that's a better example than just knowing the other party has made a move. So I think that's where it goes at the moment of nudging, but there are no doubt, I think that's a field for focus in development ideas of technology that, as you rightly say, has that impact, encouraging negotiation and movement without breaching neutrality, or appearing to breach neutrality could be as damaging as actually breaching it. So it's a very good question. I think that you're hitting the challenge at the front end of the research and development in this.
Yes, there's another on the left.
I'm working for the ODR platform of the European Commission at the German contact point. And I have a question for Mr. Simaitis. You said that there are studies that show that persons, when they are confronted with artificial intelligence, are acting less manipulative. And in my day-to-day, in our day-to-day work, we see that many consumers are, what they need is a person to tell their story to, and that they are very they are very concerned and angry about the issues, and when there is only artificial intelligence, they can put their data in. How can the need to somehow express the emotion, how can that need be satisfied?
That's as well a very good question. Likewise, like Gregor and Ross. What I can tell to you, yesterday we had very good discussion with our smaller task force of CREA who gathered here and external experts. Psychological effects of telling your story to some human or whoever, yes, and then letting it go. The phenomena of, well, this cooling down effects of telling your story, your anger, and phenomena of time as well curing is well known in mediations and, well, this dispute negotiations. So normally, yes, that decreases the level of anger, of fear, of adrenaline in blood of consumer to go to fight for his rights. Sometimes with I would like to go to fight for my rights is only connected with emotions, not about the reality, not about the facts. Maybe consumers is just dissatisfied with some behavior of a businessman or a different person, but there's got no substantiation in legal reality. He has no rights to fight for anything, but he needs to tell his story, he needs to express his emotions, etc., he or she, and that might settle the situation. In, well, these particular systems, this element is not included yet, and we discussed yesterday very interestingly that maybe, if there will be enough time in our economical team
would be brave enough, we might be doing some experimental study with our algorithms, how to include in these algorithms this at least one aspect, not, well, I'm telling my story to as a consumer or as a well, user of a system to any human being judge or mediator or whatever, yes, but I'm just put in a situation where I have to wait a little bit to cool down. So curing element of time might be as well used, and maybe in some systems it will be integrated in the system at this, okay, you told your story, you uploaded, just wait a little bit, cool down. Well, but if we would be able to design, not with this project, but maybe in different projects, a system where you can tell your story to somebody and he or she will support, or maybe a different phenomena, artificial intelligence, will support you. It's also a good question. Well, there are chatbots, you know, already chatbots, and these chatbots in certain situations are already used for, well, in disputed situations sometimes as well, in some experimental projects are already used for this curing effects of, well, guiding somebody and just at least trying to structure what is important was not as important, but things what were not important, you were allowed somehow to upload, to express yourself, etc. But you are very right that most probably what we expect from human judiciary or human dispute settlement, especially not when it's about adjudication, but about mediation, somebody to tell my story to, maybe in confidence, maybe in general sessions, that somebody listens to me, to manage my emotions, well, as well as you know, this artificial intelligence, this denomination is used to classify the systems what are simulating human intelligence. Most probably some of the system will be simulating what are you talking about. So, Graham, I'm not sure if you have seen any systems which are doing that right now.
Well, oh, sorry. I was just going to ask if I may be permitted to ask the questioner a question on that point. Because did you say you work with the Commission on the consumer ODR? Oh, I can't hear you. No, sorry.
At the German contact point of the ODR platform,
right, yes,
of the European Commission.
So my question was, perhaps I didn't make clear in my presentation why I was mentioning about the fact that we never read terms and conditions, never. Why in the report, which said that there's 22% compliance here, 40, you allowed, well, not you, the EC accepted as compliant a company that, in my word, buried the link in the terms and conditions, knowing full well that nobody ever reads them. That's why I mention about people lying all the time. I have read and understand and agree. Do you have any knowledge as whether that was discussed? Because the whole, I think the web scraping report was based on the supposition that somebody had bought something, had a complaint, and that would be maybe the time to go and read the returns policy or the terms and conditions. I understand that. But the whole purpose, and I went to some of the parliamentary sessions, committee sessions, when they were considering drafting the regulation, the whole purpose of it was to give confidence before people bought, not after they bought and have got a dispute, to give them confidence to buy from EU traders. By that meant putting the link on the home page, so that would encourage people to buy. Do you have any, was that discussed in any way, or
I cannot tell
without
you why.
breaking confidence?
I just can tell you that in Germany, on the list you showed, Germany was on the highest, is the first place, because but not because German businessmen are so very compliant to the law, but it's because there's a system in place in Germany that lawyers can make the business people pay for not putting the link into their legal notices. But I cannot tell you why it is only an obligation to put it into the agreements.
Yeah. To be fair to a lot of the business in the UK that I've been asking about it and talk to, they just don't know about this law. The authorities have never actually told them about it. And why should they go reading up some regulation of the EC? It needs to be up there in lights. But anything, I didn't answer your question, Romantis. So is that okay? Okay.
but also in our daily work, a lot of businessmen put the link into the legal notice and fulfill the obligations, but still don't know what the link is and what the platform is and what mediation is. So it does not always serve the purpose, really.
So, just any last 2 questions, let's say, because I want to let you off for the coffee break. So?
I just have one solution, you know, how to deal with this
Mike,
problem.
let's mute Mike because we are live stream.
But it will be just before the coffee break. It's not a serious one. If I heard the colleague from Germany said that sometimes the people, they have a problem, you know, with whom to discuss, with whom to tell their pain that bought their shoes without heels. So it could be the system, you know, that at first you talk to yourself and you see like a selfie, and you talk and you shout to yourself. And I'm sure that minimum 50% of people, they would feel and they will see how stupid they are, how crazy, how there are extra emotions. You simply have to deal with a heels problem and no emotions. So it could be started, you know, that you see yourself and that you talk to yourself at first. And I think that it would really mediate a lot of emotions. Yes, and have a nice coffee break.
Thank you. Regarding the timing, we are a bit ahead of, well, we are a bit lagging our schedule. May I agree to reconvene at 10 minutes past 12, okay? 10 minutes past 12. Coffee break, 20 minutes. For the speakers, may I invite the speakers to come in front? We'll make a joint picture of us. the coffee break. And I will go straight to our speakers, to their presentations, because we are lagging a little bit behind, just to speed everything up and try to stick to the agenda that we try to make it 15 minutes presentation each speaker. Yes, and we would like to start our second session with Dr. Gina Joya, adjunct professor at Tusia University, and she will introduce us the topic, let's automatize the jurisdiction. Yes, thank you.
Thank you, everybody. Thank you to the organizer for this very welcome invitation. So thank you to Marco and Rimandas that is hosting us in this very ancient university, making us feeling to wish to come back in this warm, white town. Thank you. Proceedings are particularly suitable for digital technology and algorithmisation, as already said. Digital technology can be useful for the judiciary, and it still is, for saving time and doing practical activities. If you can organize the proceedings so that the legal deeds and the documents can be exchanged between the parties and reach the judge without approaching physically the court's clerk office, that is, then the judge's office are not full of paper anymore, because all judges need to know, all what the judge needs to know and read about the case is all stored in the cloud and to be displayed in his or her computer. This is the goal of the so-called processo telematico introduced a couple of years ago in Italy. The trend of get rid of papers, documents is to see more or less all around the world, not just because of preserving the forests. Like us, like US, that has won its battle against papers, tons of papers, documents that accumulates in the offices that were used to be asked each other in the discovery when in the pre-trial they want to, the lawyers want to make sure that the counterparty has given any single item useful for evidence. Then the US introduced a couple of years ago the electronic discovery that can be very invasive for the counterparty because you can theoretically ask all the possible information, even if they are private or secret. That's why they need an algorithm able to predict the documents you would need from your counterparty in order to prove your case, documents that are allowed to be asked to discover. This is US, but it's also UK when they speak about e-disclosure, meaning the same taking of evidence process through electronic technology. In any case, in a globalized world, or just because you are an EU company, you can be doing your business in US and UK, you can be sued in front of a US or UK judge, for example, for compensation for breach of contract. And then you, in this case, have to you can be asked to give all items that are in your company database using that algorithm. Algorithms are used too in criminal cases to investigate the computer of accused people, sometimes without their consent. The artificial intelligence has one more application in finding if the accused says the truth or not. So, as has been already said before me, an algorithm can predict the decision of a judge and through that can convince the parties to settle their case in a way that is more convenient than the judgment. An algorithm is very useful to give suggestions of resolution in small claims or to settle a case where the facts and the law to be applied are already clear. Till now, the algorithm can predict a decision, but cannot make a judicial decision because the legal judicial system doesn't allow it, and because the technology, maybe, is not ready to deal with cases that have never been solved before, cases without a sure precedent. So the actual challenge of technology is to train the computer to think like a human being, the so-called artificial neuronal network. So a computer in the recent future could be able to decide any possible case without being pessimist, like most of the philosophers are, thinking that the big data owners that we know, like Google, Facebook, Amazon, they could decide to invest their money on trying government to solve litigation cases. So without being so pessimist, we can imagine in a recent future that a government decides to invest money on build an intelligent algorithm that can decide cases also without giving precedents. So it can think and have new inputs on its own without having being updated from outside. So this is the possible future, but in front of this judgment that the Minister of Justice could give the best solution, could give the best algorithm, because the Minister of Justice has all information for all the judges in the country, or if he doesn't have it, can provide them. And then if you have the best algorithm to decide the cases, it means that you have the best decision possible. So can you challenge this decision? Or you can't? In principle, you can challenge the decision. But if you have a human judge who decides about this challenge, can somebody believe that this judge is right? Or everybody believes that what the computer said is right? It cannot be, because it's the best possible decision. So this would be the end of our judicial system. This would be the end of the three powers by the enlightened time that we had for at least 3 centuries. So maybe my wish, I'm making very short, sorry, but maybe my wish would be that we should trust first judges, and we should wish having judges enlightening us on giving us precedents, and what algorithms should do should help judges doing their best and helping them on doing what is the activity, but not make decisions. So if we give the machines make the possibility to make the decision in behalf of judges, like behaving like judges, that would be the end of justice. And this is my my opinion. So let's do, in my opinion, let's do small claims mediation and mediation as much as possible through algorithms, but we need, in order to keep our system healthy, we need to have a functioning human judge system. Thank you.
Thank you, Gina, for this interesting ideas of correlation between artificial judiciary, we cannot call it, and human judiciary. And for our next topic, which is also very, sounds interestingly, on chain and off-chain conflict resolution, I would like to invite Professor Florence Giselle from Lorraine University, representing here HIC.
Thank you very much. The title of this talk is Off-Chain and On-Chain Conflict Resolution, which probably is not that clear to you. It refers to blockchain conflicts. So this talk will mostly discuss the way we could deal with conflicts on blockchains and specifically conflicts related to smart contracts on the blockchain platforms. So are you familiar with the question of blockchain, with the question of smart contracts? Okay, I may just say a few quick words more specifically about smart contracts. What are smart contracts? They are actually computer programs that are considered as smart because they authorize an automatic execution of the terms of the contract. The term was created in the 90s, actually, by a computer scientist called Nick Szabo. And the main example of this was the coffee machine, a basic coffee machine. Why? Well, because when you insert a coin in the machine is programmed to deliver a coffee. And for Szabo, that's the reason for which this is smarter than a contract that it put into writing with so many lawyers writing so many unclear terms and conditions. So this is smarter because it executes everything that is provided for automatically and almost simultaneously. So now the term is used to designate specific computer programs that all work with if-then orders. So those programs are mostly run on blockchain platforms, meaning that they are decentralized and very secure and immutable. An example of this are, for example, some insurance policies. In France, there is an insurance company called AXA who is currently offering an insurance against late flight. If your flight is late, you may be compensated for it through a smart contract, which means that if your flight is late, like let's say 2 hours late, then the computer program is informed of the exact hour when the plane landed, and then it automatically transfers the funds to your bank account. So from the minute you land to the minute you get your luggage back, you're already credited of the amount that you're entitled to. So that's how it works. So it authorizes to automatize many kind of transactions, and usually it is used to transfer funds in certain specific circumstances. this is very useful. This is currently developing. You find more and more smart contracts everywhere, and this will, of course, continue to develop. But of course, since a smart contract is a computer program, what is its relationship with the law, and can it be considered as a legal contract? Well, in practice, you find circumstances where the parties decide to enter into a conventional agreement that is put into writing with natural language, and so this is the traditional rules that apply. But in many cases, you may find what are called code-only smart contracts, meaning that it's the code that is considered as representing the terms and conditions of the contract. For those who are familiar with the DAO, which is still one of the most famous smart contracts, in the DAO terms of service, it was provided that the code had the legal authority. So any document, any explanation had no legal implication. It was just the code that was considered as legally binding. So, and this happens, this more and more happens. So probably you will tell me, yes, but in those circumstances, then there will be no breach of contract. So there will be no problem with that because the execution of the contract is programmed, so it's automatized, so there is no breach. But in practice, it's not that simple. You have issues with the execution of the contract. You also have issues in the drafting of the contract. There may be errors with the code, or what is programmed may be basically unlawful. And it is, since it is immutable, you cannot rewrite the code. It is written once and for all. It's almost impossible to amend the contract, to vary the contract, which is really, really problematic, especially in the case of a change of circumstances. So, of course, there are and there will be reasons for litigation to occur. And of course, the main thing you want to do in that case is to bring a proceeding before a court. But then it becomes, this is very, very complicated. Why? Because as you probably know, on many, many blockchain platforms, there is a rule of anonymity, or at least pseudonymity. So you basically don't know who are the other users, who are the co-contractors, and they don't know who you are. So if you want to bring a claim against someone that you don't know, how do you do it? So of course, nowadays, you have more and more possibility to disclose the real identities of people. So at least you might know that there is someone that is based in Lithuania that you might sue. But this is not the only question then, because even if you know who is the other party, you may have questions about the applicable law. Why? Well, because it's very hard for blockchain platform it's very hard to determine which is the applicable law for a blockchain platform that has no physical server. You have what are called nodes, but I heard once that nodes could be the criterion to determine the applicable law, but it's very complicated because you have so many nodes on a public blockchain that are located around the world, so that it's almost impossible to decide which node should be taken as a reference. So people suggest, and many people suggest, that when you draft a smart contract, you, one way or another, choose an applicable law for the contract, which is, of course, feasible. But all those issues are problematic, And then, even if you find the competent jurisdiction, even if you determine the applicable law, even if you get a court decision, then there are limits to the enforcement of the court decision. Why? Because the code, as I said, is immutable. So it's almost impossible to reverse a transaction. If the court decides that the contract is void or voidable, it's almost impossible to reverse what has already happened. It's almost impossible to order, for example, compensation and to enforce a compensation remedy. So the classic judicial solution is not completely satisfactory. This is the reason for which there is another solution, which is on-chain conflict resolution. The principle is just to say, well, we should deal with conflicts on the blockchain platform. So, of course, you may program self-help remedies. For example, on the platform, you have some self-enforcement mechanisms on many blockchains, like escrow procedures, like programs that provide that, for example, the automatic performance of a contract should be stopped when there is a dispute, for example. But you might also think about a very specific ODR system on the blockchain. And there are existing solutions that are actually pretty original, well, at least for jurists. And I would like to take just two examples, and we might discuss them because they are so fascinating. One of them is one of the first attempts to find a solution to this issue of solving conflicts on the blockchain. It's a platform called Open Bazaar that involves notaries. So notaries in a blockchain way to understand what a notary is. The notary on that platform has to check if the contract has been signed and if the funds are available. And once the notary verifies that the conditions are satisfied, then the notary is in charge of releasing the cryptocurrency from escrow to one of the parties. But then, if there is a conflict, the notary is also in charge of acting as an arbitrator to solve the conflict. So this is one of the first attempts to provide for a solution. Another attempt is Aragon. The Aragon platform provides for an entirely digital jurisdiction with semi-anonymous judges, semi-anonymous arbitrators that are subject to a reputation system. So let me explain how it works. If there is a user that wishes to dispute the execution of a contract, for example, this user posts a bond. So this bond will be returned if the dispute is decided in favor of that user, otherwise he loses it. So he posts a bond and he posts a brief with his arguments. This opens a market where any user in the platform may become a judge by posting a bond, okay? And then 5 judges are randomly selected from the users that posted a bond. The judges read the litigants' briefs, and then they issue their ruling. So it's of course a majority that determine the outcome of the dispute. And if a judge rules with the majority, he is rewarded. And if it doesn't rule with the majority, he loses his bond. Okay? And then you have 2 possible appeals. So there is an appeal, the first appeal that is possible with basically the same bond system. And the final appeal is made to a panel of 9 judges, and it's called the Supreme Court. And these judges are selected among the most successful judges in the network, since there is a reputation system. So it's semi-anonymous. So you won't know the real identity of those judges. You will just be able to identify them on the network, and they will be evaluated on the network. So for the Supreme Court, the judges are selected only among the most successful judges. So, and of course, if you want to bring an appeal before that Supreme Court, there is a larger bond that is needed. You need to post a larger bond to prevent the wasting of the system resources. So that's how it works. It's something pretty original. There is an ambiguity about the question whether those judges should make a ruling by referring to existing laws. Could you write your brief with the help of a legal counsel? So for the moment, we don't know all the precisions about it, but that's how it works. And you have more and more projects offering those kind of solutions with users that can become judges or arbitrators or whatever you want to call them, and judges that are anonymous or semi-anonymous. So this is basically what I wanted to highlight here, because I think it's a call for intervention and thinking from the part of jurists. We should probably look at what is currently being developed on those platforms and think what we could say about it, or what ideas we could probably suggest, because to me, all those solutions and platforms are currently evolving largely outside of the law. It's mainly practice, and we could probably see if those new systems are compatible with all existing legal principles. Thank you.
Thank you very much, Florence. It was, thank you, Gina. It was really fascinating to know that there are rule-based dispute resolution systems which are developing outside the realm of lawyers' work, legality work, and which are included in the systems of blockchain. I believe Lithuanians, especially those ones who are issuing ICOs and that are practicing in blockchain and development of them and using them, I would be very interested to learn about them and how they might be used. But for us lawyers in Lithuania, that would be a really nightmare. Try to qualify what is the value, legal value of that decision of these judges, how do you call it, etc., and how to use that in our practice. If the dispute will arise regarding the decision of judges, I think that's the question for the Supreme Court of Lithuania to decide and to rule upon it. Thank you very much for a very interesting presentation. And now I would like to invite to present the topic of the proposal of a quantification of the normativity of the verdict, two professors of University of Naples, Federico II, Francesco Romeo and Ferruccio Alueta. Please, the floor is yours.
Thank you, Rimantas. First of all, I would like to thank the University of Vilnius and for this organization, which is almost perfect, and especially I would like to thank Rimantas Simaitis and Mida Markevičiūtė for the warming welcome in a cold weather, from my point of view. Anyway, Rimantas and Milda are part with the University of Vilnius, are part of the CREA project, which I lead. And they are maybe the most performative part in the project. I would say yes. And I thank you especially for this commitment commitment in the project. Anyway, we will not speak about, I will not speak, and he will not speak about the project, the CREA project, but about an evolution of the project, another project, I would say. Our question is it possible to quantify normativity? I think most of you are jurists. Am I right? Yes. So, no, you know, so you will experience some problems here. But jurists will not have any problems. You know what normativity is, or you feel that. Let me come back just a minute to what the President of the Supreme Court said. Please, he made a warning, please pay attention to the human touch in this algorithmical point of view on justice. Okay, that is exactly what I want to do. In the CREA project, it's possible to have attention, to pay attention to emotionality, because equitative algorithm or fairness algorithm could permit some kinds of exploitation of emotionality of parties and use of the emotionality of parties in the algorithmical solution. But now the question is, what about the emotionality of the judge? The touch, the human touch about which spoke the President of the Supreme Court. This human touch is part of emotionality too? Yes, I think I have to answer yes. It is, but we have to analyze very good what normativity means. So, and if you wanna do something new like quantification of normativity, we have to ask old questions like this: what is normativity? But giving new answers from new point of view, what we are trying to do. So, at the beginning, we take the definition of Hans Kelsen, and I will say of Herbert Hart too. So for each jurist, there are names very known, very well known. Normativity has something to do with das Sollen for Kelsen and with the ought in Herbert Hart. What is ought? Ought to be something that ought to be. What is something that ought to be? It's not something that it is here. I'm not handling with a glass or with a bottle with water. I'm handling with a transformation of the reality. Something that ought to be will be. It's not now, will be. Anyway, Kelsen and Hart say the same thing. That is, normativity is the core of our business, of the definition of law. Law is, per definition, normative. There is a vision of a future. The judge, the law, they give a vision of a future that ought to be. This is the normativity. Okay, that is from what is to what ought to be. I cannot draw a logical conclusion. It will be a fallacy. A very known fallacy. The name of this fallacy is naturalistic fallacy. Now we have the problem: how can I use the normativity, this ought to be, in a quantified manner in programming my algorithmic or my software for the decision of a case. Okay, we have split our speech in three parts. The first one is this one. Second one is of Professor Aulita, and the conclusion will be my part, because we have different fields of endeavor of research. I research on artificial intelligence and law and general theory, and Professor Aulita is a researcher on procedural law. So, beginning with that, normativity means an act of will from one person addressed to other person in order to have a behavior transforming the reality in one sense and not in another sense. This is the definition of Hans Kelsen, an act of will of one person to other person in order to transform the reality. I say you have to do that, you have to do that. This is the legal normativity for Hans Kelsen. Okay, beginning from this beginning, we will analyze now what happens in the judicial proceeding.
Thank you, Francesco. Our work faces the need to scientifically measure, if possible, quantify the normative value of a decision. This is because now many national systems outside of the system based on stare decisis led the jurisprudence to become guiding principles such as to filtering appeals, rejecting claims prima facie, or simply to manage proceedings along different paths. This raises the need for an appropriate measurement and to assign a normative quotient with non-arbitrary criteria, taking into account all the elements that we can elaborate to find the marginal normative range of a single decision. I will provide you example from 3 different systems in which the need is particularly felt: French system, Italian system, Brazilian system. Our goal of objectivity and standardization seems possible because the first obstacle has been removed. I mean, the material access to data. All data are now at our disposal. Where available, the electronic civil proceedings create a natural warehouse of all decisions. And for the Supreme Court's collection of decisions, we normally have the total set. We select French system, Italian system, Brazilian system, because French has a peculiar tradition opposing normative judgment. Italian has current development we are facing in procedural law, and the Brazilian recent civil procedure code is a sort of border of hybridization of civil and common law systems. France has been characterized since 1803 by the ban of arrêt de règlement. Despite the prohibition of giving reasons for judgment on the sole basis of the precedent, which would otherwise end up being a general rule, at least since 60s, la jurisprudence constante has been regarded as a source of law by operators, and in the Court of Cassation, the conformity of the ruling on appeal with the established case law of the court can be used as a ground for non-admission by the formation restreinte. In France, the degree of normativity is so significant that the Court of Cassation itself has made a sort of ranking in order to handle the way to publish the judgments. They have 5 degrees marked by capital letters. D for so-called arrêt d'espèce, with no degree of normativity, just for diffusion. D stands for diffusion. Then B, judgment that can be published with a summary in the Bulletin d'information de la Cour de cassation. Then the full version published are for judgment marked as P as publication. And then for degree I stands for internet website of the Cour de cassation. This is for judgment with great social impact, family matters or social housing and something like that. And then the last degree marked by R, judgment that are published in the Rapport annuel de la Cour de cassation. That seems that in France they are searching for a specific weight of a single decision, a sort of calculation of normative energy that it supplies to the whole system. It is empirically felt as a need, and we try to make it more objective at the end, as we hope, of our work. It's not related with the predictive justice, our work, absolutely not. Predictive justice that is experimented now currently in France too involves mass analysis. This is logically antithetical to that because we try to calculate the specific weight of a single decision. In Italy, we are facing transformation of procedural law, and we had a recent development through which now we can have sufficient condition of the justification of a judgment in a single precedent, and then we can have a sort of necessary condition for the judgment of the ammissibility of the appeal to the Corte di Cassazione that derives from the compliance with jurisprudence of the court. And the president of the Italian Supreme Court issued a programmatic document on April 2016 in which he tried to recognize how you can find an orientation in the jurisprudence of the Corte di Cassazione. And he wrote down that there is a orientation when a decision is made by joint chambers, otherwise when it is consolidated by a single chamber, or when there are few judgments or at least one, but convincing. As everyone can see, is an empirical measurement of the normative value of the judicial system. And for example, no mention has been made of the obiter dictum, and although the obiter dicta are listed as normative factors in some precedents of the Corte di Cassazione itself. The need to measure the normativity of a single decision is now felt in Brazil, where in 2015 we have a new code entered in force, and the uniform jurisprudence, among other measures founded on the jurisprudence, is taken into account by articles that stands principles like the courts must conform their jurisprudence and keep it stable, intact, and consistent. To do complying with such a principles, we can have measure like that one established by the Article 332, through which is possible a preliminary rejection of the application when it is against the existence of a consolidated orientation of the courts. So that it's clear that in Brazil the technique that enhanced jurisprudential deposit is oriented to the efficiency of the judiciary. But there is no doubt that just when the efficiency of the organization make use of an instrument in antagonism with the right of access to justice, it is here that the objectification of the measure and standardization of the index marks importance and significance. That's why we, Francesco and I, have decided to go on with our work.
So, and I finish in 2 minutes, okay? 3. Thank you. In 3 minutes. And now, how could we handle with this reality? A judge make normative assessment of the law, changes the law, and some changements are important, some are not important, and some sentences of the Supreme Court are normative, but the question is, all the sentences of the Supreme Court are normative or not? Okay, give a definition of normative, which is consistent with the definition of Hans Kelsen, so we are in peace with the tradition, with the jurist tradition. But it is new, and it is useful for a quantification. I give it to you, I propose it to you. So, I think normativity has 2 parts. One part, the first one, is a temporal shifting. As I said, a will is to the future. A temporal shifting that takes place in cultural representation and allows the contemporary evaluation of temporally separated realities. The oath establishes the future of an event as due or possible or simply probable, but the oath doesn't establish the reality now. So there is this shifting in the time. This is one part of normative, always present. And a temporary shifting is a quantifiable thing. I can quantify something here. Second typical component of legal normativity is the expectation or trust that the oath will come true. In a legal normativity, everyone expects that the law will be accomplished, that the sentence of the judge will transform the reality in the way the judge wants. Everybody expects that the representation in the law will come true. This is the second part of normativity, the expectation. So there are 2 parts which are different. The first one is possible to quantify in different ways because it's a spatial and temporal reality, always if projected in the future. But I can use statistical analysis in order to analyze it. The second one is a personal position of the judge or of the person. A personal position is a subjective one, as the human touch that said the president of the Supreme Court. Could we do something here? So if you want to measure normativity of a sentence of a president of the Supreme Court or of a tribunal, we have to just to measure the first part. The second one, the subjective part of the judge, is not possible to measure it in the normal ways, but it is possible to handle with it, letting come this part in evidence. So if I purify normativity from the two parts, and in two parts, from one part. If I purify normativity from one part and say there are two parts, one part can be handled quantifying it and using it in our artificial systems. The other part is subjective and is not possible to quantify it, but I can deal with it. Okay, if I do that, I can take in evidence what the judge is doing, and if it's permitted or nice or I don't know what. So any kind of judgment on the other part of the normativity of the judge is allowed. So I think in this case we will gain something, and we can handle better with the normative system. This is our work. If you want to read something or the whole work, it will be published on the proceeding of the IRIS Congress, coming IRIS Congress in Salzburg, and otherwise I can send it to you. Thank you.
Thanks a lot for representative of Naples University. And regarding publications, just a small comment to all the speakers would allow a possibility to develop further on and on the basis of your presentations, and to prepare articles, scientific articles, and we will invite all the speakers to publish them in special edition of Vilnius University Scientific Law Journal. We call it Teise Law. So we'll invite all the speakers to, well, shape their presentations in form scientific articles, and we will try to make a compilation of these articles and make them mailable. They will be available on the internet as well in Teise Pro portal. So participants of the conference as well would be able to read your thoughts online. Thanks a lot, and now I'm turning to my colleague at Vilnius University, lecturer at Vilnius University Faculty of Law, Dr. Donatas Murauskas. He, for many years, was representing Republic of Lithuania in the European Court of Human Rights, and therefore these fundamental human rights issues are very hot to him, and he very sensible to him, and he's very he has deep knowledge about these ones, and he as well has an interest in artificial intelligence and started his research and doing some research with in this intersection of artificial intelligence and human rights, where the artificial intelligence can be used for improvement of the system of protection of human rights, or they might undermine the system. And now he will present you a topic of using algorithms in courts. Is it strengthening or undermining the right to a free trial? Donatas, the floor is yours.
Yeah, thank you so much. And ladies and gentlemen, it's really nice to be here, and thank you for the invitation to this session, Rimantas. Thank you for organizing this really great event, Milda and Rimantas. This is a really fascinating to be here, and it's great to be here with all the experts of the project and those who are not, who do not belong to the group, and being kind of an external viewer here and considering the discussions academic nature, I would allow myself to take a little bit different view. So when I started actually to explore the explosive topic of interaction of artificial intelligence and human rights, looking from the perspective of a practicing lawyer in this field, I thought it actually gave me a headache, and I thought, boy, oh boy, if there is a case in the European Court of Human Rights dealing with algorithmisation of judicial decisions, that would be really interesting. All the interaction of of human rights and technologies deserve at least 2 tiers of dealing it with at the European Court of Human Rights, finishing with a Grand Chamber decision, which would definitely be not unanimous, and only imagine this having artificial intelligence issue, which creates a vast field of uncertainty here. So, what is really interesting that I found it amusing when I discovered that in many researchers, at least in some of them, the scholars actually suggesting that the debates need to be reconstructed, kind of, on many levels in order to achieve a really sustainable level of policy and lawmaking in terms of technology progress. What I mean here is that what was touched by you in your presentation, this is like we usually discuss some implication externally from what the law tells us. So what I try to do is to discuss currently applicable European Convention as one of the most, as you know, supranational human rights protection mechanisms in terms of its compliance with societal progress on algorithmisation. So my alternative title would be definitely not this, but would be probably, was the right to a fair trial designed considering possible use of algorithm in the practice of courts? After the Second World War, sure, probably, definitely yes. So here some. Today I will make few remarks on ethical considerations and on the new recently adopted European Ethical Charter. In this regard, also, I will talk a little bit about the legal framework of the European Convention in terms of the right to a fair trial. And then I will touch a recent change of the jurisprudence of the European Court of Human Rights and how this change might fit into this discussion of artificial intelligence and human rights. So the funny thing is that 4 days ago, there was an opening of a judicial year of the European Court of Human Rights, and there was a guest speaker, the president of the French Constitutional Council, Laurent Fabius, and he actually referred to to one of the cases of a constitutional court related to the use of algorithms, representing one of the major trends in France and in Europe. What is actually important, the way he represented it, he underlined the restrictive character of the decision. And here, this might be the trend. And if we leave the current status, this might be, I think, the trend. This is my kind of a hypothesis here. And apparently, the courts are already ruling on the way algorithms to be used by national authorities. But considering uncertainty which is surrounded by the actual use of algorithms by national authorities, there are risks of overuse and misuse of algorithms. And during my contribution, I do not refer to algorithms like in general or artificial intelligence, but I refer more to one particular way the national courts may use algorithms, namely drawing up scales in certain disputes. So, in other words, this is one of the focuses of judicial decisions as enhancing human agency or smart agents. As once assistant of a Supreme Administrative Court, I fearfully state that the greatest challenge to assistance of a judge currently drafting judicial opinions is slowly crouching to our national courts. So a little bit of drama here. And so few words on ethical charter. So most of you probably know the European Commission for the Efficiency of Justice of the Council of Europe has adopted its first European text setting out ethical principles relating to the use of artificial intelligence in judicial systems in December. And the Charter provides a framework of principles that can guide policymakers, legislators, and justice professionals. And there are 5 principles, and this is the principle number 1, the principle of respect of fundamental rights. And I would like to reflect on considerations made by the expert group. In the context of the requirements of a European Convention in this regard. So my claim is following. So the use of algorithms may be aligned with human rights standards, yet the current convention framework, I talk about European Convention on Human Rights and Fundamental Freedoms, does not ensure effective safeguards of such standards. So to put another way, I believe that particular systemic features of the mandate of the European Court of Human Rights seems to make the right to a fair trial rather ineffective in light of the use of artificial intelligence in national judicial systems. So when we discuss, what we discuss a lot when we talk about algorithmization of judicial decisions, we discuss a lot the lega fedenda of related to imposition of particular ethical standards to developers and users of artificial intelligence, mostly focusing on transparency requirement. What is partly missed in this debate is actually the context of actual implementation of rights prescribed in the European Convention of Human Rights. So it is underlined in the commentary of the first principle of already mentioned charter, of ethical charter, that when artificial intelligence tools are used to assist in judicial making, it is essential to ensure that they do not undermine the guarantees of the right to access to the judge and the right to a fair trial. And I think this is a fundamental key point. Let us take a look on what the right to a fair trial actually requires, and what is the scope of the European Courts of Human Rights supervision in this regard. And here are a few elements, few features. I don't even refer to the independence and impartiality of judicial decisions, which is a really problematic point, but we would need probably 3 hours to discuss it. And here are some other important elements here. So what is meant by Article 6 is, first of all, not a substantive fairness, but procedural fairness. Then what the court doesn't do is, it is not dealing with errors of fact or law allegedly committed by a national court. And the purpose of the analysis of the European Court of Human Rights is actually whether the proceedings taken as a whole were fair, not really dealing with a particular element, but really looking to the proceeding as a whole. So in the context of algorithmization, I do not touch independence and impartiality, but it is enough to look at the principles of how the European Court of Human Rights deals with the administration of evidence of national courts and reasoning of judicial decisions. When we discuss reasoning of judicial decisions, the guarantees of Article 6, they include obligation for us to give sufficient reasons for their decisions. Again, much importance on the work of the national court, not really creating a particular really clear standard here, but really allowing the national courts to develop their view here. So when we consider the risks created by if we use scales even to a limited scope, we may touch such issues as issue with correlations. So the larger is a database used for correlations, the greater the chances of finding recurrent patterns and the greater the chances of making error. Then the second thing is, again, we discuss a lot about absence of a unified approach on accountability and supervision of algorithm. And the thing which is the most probably interesting is the locking decisions. So locking the case law is the possible tendency of a judge to stick to the existent case law. What was kind of a little bit discussed in your presentation, but discussing the normativity issue. So, and here it is also really important to underline that the case law of the European Court of Human Rights even incentivizing national courts to follow its case law, which may have even a reinforcing effect here on judicial deliberation relying on algorithms. So considering risks of error while employing algorithms in judicial activities in presence of discussions as to ensuring accountability, the use of algorithms may become a formalized routine and depend on a workload of a particular court. And the fact that the European Court of Human Rights underlines importance of legal centering may even more so lock the case law of national courts. And in my view, algorithms may be viewed as equivalent to assistants of a judge and who are more technical, yet with their own flaws and lacking consciousness, which eliminate this poetry or human touch or emotions. And now when we go to the practice, so what is actually the violation of a right to a fair trial in this regard? So ensuring applications being considered by the court, it is highly questionable on whether the applicant who doubts validity of the algorithm used in his or her case is actually capable of substantiating that there was, in words of the European Court, manifest error of judgment, a decision was grossly arbitrary, and the way the court considered the case could be identified as a denial of justice. So we have this a particular minimum standard, which might be even lowered in terms of national judicial decisions, because the minimum standard, which would allow us not to say that the decision was grossly arbitrary, would be much lower than the current standard existing without algorithms. So I would say there is a risk here. Because the standard of the convention itself might lower the standards of the national decisions which employ algorithms. So here, if we again hypothetically look at what might be the outcome of the case if such case reaches the European Court of Human Rights, I would say there might be a dilemma for the courts to be proactive and to give a particular standard here, a really rule on a particular guidelines on how to deal with such cases. But I would say that even more probably that the court would leave this situation unsettled and would issue actually the inadmissibility decision as unsubstantiated. So, but what is happening currently? Okay, so in the context of current so-called new phase of a case of the European Court of Human Rights, which is called a procedural embeddedness, so it focuses more on a shared responsibility of stakeholders of a convention. There is a potential for national jurisdictions to experiment. At the same time, this trend encompasses the challenge that the court might give a standard-setting decision in any case. And here, what I offer and what I was thinking about it a lot is that I would suggest that algorithmization should not only be discussed in terms of creating clear standards in terms of judicial procedures, but this process should be included into the debates on the future of the convention system as soon as possible, aiming to conceptualize the normative ground for the use of algorithms within the convention legal framework. So probably I will stop here. Yeah, thank you.
Thank you, Donatas. And now I'd like to open the floor for question and answer session. Yes, we have a mic. Well, any questions? Any comments from the audience?
I have a question for Florence. About the system of an ODR based on a blockchain. But I have a doubt. Can you use a proof of work, a proof of content to admit the decision of the ODR, or it's a different way to a different system, not blockchain based, but an ODR just focus on smart contract based on blockchain? Thank you.
If I understand your question well, it's is this ODR process based on a smart contract?
No, is it based on a blockchain system?
Yeah, it's within the blockchain.
And the decision of the ODR is based, it's passed through an approbation.
Absolutely, it's absolutely, but it's online. And if you're familiar with the DAO, how you know the first DAO, you had mechanisms for voting within the platforms. So it would be the exact same kind of mechanism with judges that are basically voting, and they are not supposed to know each other. They vote online, and then the decision, once the decision is reached, it can be enforced through smart contracts, for example.
So is it a permissionless?
Come on, Mike.
Yeah. So all this, of course, all these kind of mechanisms are designed for public blockchains, where there is at least a principle of anonymity that are anonymous or pseudonymous. Because the reason for which those mechanisms are designed are just the fact that it's almost impossible to bring a claim before a traditional court or even a traditional arbitration court.
Mm. Okay, thank you.
Thank you. Here we have a question. Mike, here.
Thank you very much to the panelists. There appears to be a lot of focus on the process of the way in which legal technology will change the various processes of law. But how about the disputes? Do all disputes lend themselves to law tech?
Could you please specify, do all the disputes do what?
So for example, if you might have a family dispute, you might have a criminal dispute, a commercial dispute, civil law, so do they all lend themselves equally to law tech? What are the differences in the way?
Okay, who would like to take this question? Well, once again, most probably, we have many questions and not so many developed answers. We are still developing, but what do you think?
If I understood well, there are some fields in law which cannot be now handled by these systems. I think penal law, so how do you say? Criminal law, yes, strafrecht, could not be handled by this system by now. Otherwise, by now there are no limits except of this one. All the rest is in one handling or research field. We are trying to differentiate it, especially what administrative law is and civil law is. But commercial law and civil law are by some way the same thing. They are not so different. And I think commercial law comes from family law. It's an origin, an ancient origin from which sees first family law and from family law commercial law. And in the history of the codes, commercial law and private law are always been in the same legislation. So I would say what is private law, commercial law, and civil law they are handled by the same system. Criminal law is not handled by this system. Administrative law has a special system built for them, especially for them. I will make this differentiation. There is another big problem about which spoke Donatas. That's right. And briefly spoke, Donato, which is a problem with democracy. The problem with democracy and maintain the rule of law is, by my point of view, the most important issues in using these systems. They are not so transparent. So what democracies, when issues of democracy or politics are in question, it's important to build some systems which are apart from the other.
Thank you. Yes, we have a question here. And over there. Okay. First of all here and then there.
Okay, thank you. Let me just, so I can see everybody. Your question was, can all legal problems be solved by legal tech? And my answer is, up to a point, yes. Even in criminal law, if it's a matter of imposing fines, if someone gets imposed a fine by a legal tech system and accepts the fine, great. If they don't like it, they have to be able to access a court to ask, is this a justified fine that I got? So I don't think the criminal law sphere is completely excluded. But it's up to it. So, but that brings me to the picture I showed you this morning about unpredictability. And if we concentrate then on the unpredictable, let's say my group 4, what happens in group 4, nobody knows beforehand. There may be compromises. Parties may change their minds in the course of the process. And the outcome will usually be something that nobody could predict. And it will not be usually a simple yes or no. I mean, we judges take a lot of decisions where we say partially yes, partially no. Right now, from what I have seen, that is not something that legal tech handles very easily, this kind of the compromises. Let me share with you just a small anecdote. I had to write a paper, and there was a section where I quoted a couple of paragraphs from the Dutch civil procedural law. And I always put my articles through the word control mechanism to see if all the spelling is correct. And it came back that this passage was vague, according to Word, which it was. But that is deliberate. I mean, legislation is deliberately vague because you never know what is going to happen. So this ambiguity is native to legislation. So I understand that you would like to try and have unambiguous legislation. But the great strength of legislation is that it is ambiguous enough to be able to deal with things that we cannot foresee yet. So my plea for ambiguity, which is where I think the real crunch comes when it comes to the justice system and to what judges do, what courts do, and what people need in order to be able to lead socially viable lives. Ambiguity, don't forget.
Thank you, Dory. That's really a good comment.
May I answer?
Okay.
Ambiguity
yes.
is power to the judge. Yeah, the other face of ambiguity is the power to the judge. And so you are saying, please, power to the judge. You can be...
no, I'm saying power to ambiguity.
Power to?
Ambiguity.
No. There is no possibility to come out from these two possibilities. So power to the judge, ambiguity, yes, power to the judge, and his will is the most important thing, his will. I want that you do that. And not so much power to the judge. Okay, a little bit, yes, the human touch. But I would like to know when it happens. I would like to know when it happens. So I don't like this ambiguity.
May I add another thing, that in some situations, just enable for us to live a better life with more quality, sometimes too much ambiguity is also not very healthy. And that's what are we talking about? If we want to algorithmize something, most probably we need to have certain specific sectors, specific spheres where ambiguity will be minimized or maybe even extinguished to a certain extent. Most probably not 100%. It's not possible currently. Having due regard to our tradition of legal making, lawmaking, and legal drafting, but minimizing possibilities of ambiguity might create a gate for algorithmization of that specific part of our life and legal work. But I'm not telling that all the disputes, all the sectors of social life shall, well, be drafted in a set of rules. That's not possible. And where you will have your human touch and ambiguity, most probably you will.
My problem with a little bit with a tendency in the discourse is the contrast between rules and emotions. It's my strong conviction that fairness, which is the basis of all law, is an essential social faculty that we have and that enables us to live as a group. So that's a continuum. It's not one or the other. And the continuum can also shift. I see that people are so used to being fined something that comes from a list of fines. If you speed more than 10 kilometers, the fine is this, and if it's more than 20, the fine is that. People accept that. And I think 50 years ago, they probably would not. So that there is a shift there towards a certain degree of rationalization. And we all like to rationalize. But we should realize that that rationality also is also based in our sense of fairness. And we should not forget that.
Thank you, Dory, for your comments. Now I have two questions from that side. And most probably will, that side, yes. Could you please, yes, bring in the mic. Thank you.
Doris Pestanikas, Infolex. Probably a question to the Professor Orleta. I'm very excited on your idea of measuring normativity of co-decision, probably, or part of co-decision or sentence. It's I don't catch the total idea. But what do you think nowadays technology can compete? I mean, artificial intelligence compete to the judges. You made example in France when the judges decide themselves normativity, and of course it's a traditional way, it's a good way. But Google does it and call it relevance or importance. It's something similar like that. Of course, not exactly and far from that. But what do you think about possibility of technologies?
Francesco is an expert in the way to calculate the factors that we have previously to select, and selecting the factors that we have to overlook in order to evaluate the normativity of a single decision is the fundamental finding of this work. I think, just for instance, that if you have a judgment not overruled for a long time, this stands for a great capacity of normativity, so that probably you can amend the statement that the Italian Prime President of the Supreme Court made, saying that a convincing single decision could found a subsequent judgment, because convincing is ambiguous, and it means that each judge selects what he wants. We don't want that. We try to gather factors that can objectivize the meaning of convincing judgment. So you can cooperate in finding the factors: social factor, doctrinal factor, time factor, the way to calculate the power of each factor is something that belongs to Francesco. He explained me several times the way in which mathematicians do that. I'm not so able, but probably he does and can explain.
And notice, are you a jurist or yes? Are you a jurist? No. A technician. So you know the ways in order to calculate that.
Yeah, really, we use similar tools in our product, but we use just big data.
Just big data. But when I know the extension, spatial extension, that is, which fields of law are influenced by the sentence, and when I know which is the transformation in the society brought by the sentence, transformation in the society is behavior of people. It's a factual thing. I can study it with statistical analysis, like discriminant analysis, and so you know that. And having a statistical description of the fact give me a measure of the importance of the penetration of the sentence, because as I said, the normativity is an act of will which changes the reality. It's not the reality as is. Changes the reality. I want to see how much reality has changed after this normativity. So, and I can measure it. That's just what I want. I don't want to measure the feeling of the judge. I don't want to do it. It's a human thing, and it has to be a human thing. And I don't want to simulate that. Just to measure with statistical analysis this temporal shifting of Oud or of Zollen. That's my another thing. Just another thing. There are artificial intelligence systems which are ambiguous. All machine learning is ambiguous. Is not totally predictable. Genetically, it's not totally predictable. It's probabilistic. So what happens if I use these ambiguous intelligence systems, machine learning system in the law field? What happens? Are we ready to accept that? I have an answer already. No, we are not ready to accept that. I made the first one of this machine learning system. I made it in the 90s. And the observation of all the jurists were the same. All jurists said, "Oh, what can we do with a system which is not predictable?" But if I demonstrate to you that until now it has worked like the Supreme Court in Italy, until now it has given the same sentence like in Italy. It was for car accident, so it's very easy work. But at that time it was not easy. It was the first one, but I mean, if we give the same sentences as the Supreme Court, this should be enough. This should be proven after some good results that it works. Okay, I cannot predict everything. It could be that somehow in the future it will go crazy and give some crazy solutions. Could be. It's not predictable.
Thank you. And due to the time restraints, we are lagging behind. I shall do the last question here.
I'm sorry, just only a statement to underline the position of Romeo. I'm a president of a constitutional court and of an administrative court. And I have, in this respect, just another perspective on this matter. And I think it's also a question of the state of law, indeed, and the legitimacy of how to implement the use of algorithm. And I think there's a big danger. People do what they can do and what is possible. It's always a question of power and of advantage. And when you don't restrict it, they do all what they can. And I think we have to keep an eye on this also when we design the law for using the algorithm. That means not to react, but what is necessary or what are the minimum of things to make it transparent what algorithm will be used. I think that's the main question we have to look at. It goes a little bit in your direction also, what I'm saying. I'm sorry, that's not a question, it's just only a statement.
But we agree with you.
Yes, I know.
The question is not the feasibility and
of course
of this system. They are here. We can use it. We can perfection it for us. The main question is your question. Yeah. What about our democratic system? It changes everything, and we have to discuss.
Yeah, and I agree totally. And when I regard the discussion, especially in the government and the administration, what they are doing to use algorithm, or the discussion very often, it's just a little bit ethic. We look a little bit ethic, in the view out of ethic, but I think it's not enough.
It's not enough, yes. Sorry.
Thanks a lot. Thank you for your questions, for your remarks. Thank you once again, panelists, for interesting, intriguing, and very debatable issues you've raised. Now, before going to lunch, let's agree on the time limit. We're coming back. So 1 hour for lunch, I think, shall be enough. Let's come back and let's reconvene and start our third session at 2:45. Now it's 2:45, so 2:45. The lunch is served in the cafeteria, the same cafeteria you had coffee, so you have lunch is waiting for you there.
We are two minutes late on the scheduled time. We are beyond 2:45. So let's start the new session. We have to give some information about the panelists, because we will not have Katerina Zajce, Jaka Sepec. Both they will be substituted by Maximilian Gale, and we will not have the speech announced by Marco Giacalone, because Marco got sick. He doesn't feel well, so he preferred to stay in the audience. And then the first, when David, who is now arranging the computer support, will be ready,
Trying to find.
we can start this third session. And I will keep for each speaker the 15 minutes in which everyone is allowed to give his presentation. Are you ready, David?
Well,
you are consuming your time. I would like to warn you.
I cannot find the links. The links that were on the
Okay, 30 seconds of extra time, not more.
They're not. And I cannot connect these because I have the links there.
David Restrepo Amariles is assistant professor of law at HEC in Paris, and the speech he's going to give is about accountability and algorithmic decision making. The floor is to you.
Thank you. Okay. So, hello everyone. So my name is David Restrepo. Thank you for the introduction. So I'll be talking about Smart Lawyer, which is a project we are conducting at HEC Paris together with École Polytechnique, which is the engineering school. And all of this is very much actually linked, of course, to the CREA and SCAN projects, and to the idea that there is some accountability behind these tools that need to be sorted out, at least investigated. So my talk today is actually about access to justice, but not about courts. And it's very much about asymmetry of information between lawyers and clients. So my question is, how many lawyers are there in the room? Okay, so probably you'll be concerned by this. So one of the issues that we often see in what we call regulated professions is about the asymmetry of information between consumers of the service and those providing the service. So what type of information do clients or users or consumers of legal services have on their hands to choose the right person providing for those legal services? Is very much the question I want to address. And this is quite fundamental, actually, for accessing justice, since it is not only that small claims might be settled out of court, but the way persons can choose the right service might also have a bear on the type of justice they are actually accessing to. So this asymmetry of information, and I'm going to go through 4 parts in my presentation. This asymmetry of information is quite relevant when it comes to regulating the legal professions, the tools that can be used to regulate or deregulate the legal profession, and basically what constitutes, to my opinion and the group of researchers I'm representing here today, the technological tools that can be set up or that are being developed to provide that information to consumers. So a first probably interest, just kind of sketching out the field. when we talk about regulated professions, we talk about ratio legis, of course, of this regulated profession, which is the idea that we need to regulate them because there is a market failure in terms of the information that individuals dispose of, and the clients of that service, and those actually providing the service. So these regulated professions, from which you have actually some of them in the chart by a report done by the Institute of Advanced Studies, shows the index of regulation of these professions. The higher it is, the more regulated the profession is. And as you see, there are two that concern those trained in the legal field, which is lawyers and notaries. Now, the regulated profession usually concerns the entry requirements and the conduct that is regulated as well. So these regulated professions actually are under, let's say, the scope of a reform both at the European Union level and at the national level. So there is a question as what are the best tools, and I think the OECD has done some work as well, what are the best tools to get a single market even for these professions? How can we actually regulate at the European level these professions, or at least how can we decrease the entry barriers and the conduct barriers of these professions across the European Union? So this was discussed in a forum in 2015 and 2016 of the European Union, and I think there is a hint that is probably emerging out of this discussion, the idea that very similar to what the European Union has issued in a communication in 2016 about the collaborative economy, the idea that some reputational tools may be useful means to regulate, or at least useful means to provide users and consumers with certain information and then decrease information asymmetry. So in this case, you see there are citation of the collaborative economy agenda, where the EU says that rating and reputational systems and other mechanisms may reduce risk for consumers stemming from information asymmetry. Now, this is, of course, as I mentioned earlier, this has had an impact on what we think should be the appropriate regulation for regulated professions. And in 2018, the European Union enacted a directive which basically sets the framework for regulating, or for the framework under which countries should undertake reforms of the legal profession and other regulated professions. And Article 7 specifically in relation to proportionality, so the principle of proportionality in the terms of what are the measures that are taken both in relation to conduct and entry of the regulated profession, should pass the test of proportionality. And that test of proportionality in particular in Article 2, Paragraph F says that basically countries, before adopting any provisions, should consider the scientific and technological developments which may effectively reduce or increase the asymmetry of information between professionals and consumers. And Recital 17 specifically says that this may indeed involve updates in access requirements for a certain number of professions. So briefly speaking, we are talking about new tools, including technological tools, which could decrease the asymmetry of information. It could reduce the need for regulating those professions, both at the conduct and entry level. And one of the professions that is specifically targeted in these discussions is legal profession. Now, this on one side, I'm just setting up a framework here. And the second is a set of decisions in France, which started in 2015 about or concerning what we call legal techs. And those legal techs in particular provided or connected consumers to lawyers by providing a platform where consumers could go and select their lawyer, but also providing an assessment or a ranking or a rating, as you may want to call it, of lawyers in that platform. If you are a lawyer and you Google yourself, you already have a sort of rating in Google. But this was, of course, providing in a systematic basis and with, let's say, what we could assume was a standardized methodology. So in the first instance, so the Paris bar filed a claim before civil court, where basically the discussion was whether this platform was authorized or should be authorized to issue, first to put the clients in connection to the lawyers, and second to rate actually the lawyers. And in the first instance, the tribunal said it was not possible because first of all, the legal profession was a regulated profession, and second because the information that was handed to the consumers was not reliable. I'm just going to use reliable at this stage. Well, this decision was reviewed by the Cour de Cassation, which is the highest tribunal in France, and the tribunal basically said, well, if you look at this from the perspective of the consumer, this is actually a quite relevant platform, and as far as they are providing to the consumer loyal, clear, and transparent information, actually these platforms are legal. This decision came down then to the appeal court, which had to decide the case, and basically the appeal court said, okay, well, following the decision of the Cour de Cassation, they must disclose the criteria that is used for comparisons and their coefficients. So in other words, if we connect on the one side, the trend in European Union regulation and the trend in the jurisprudence in case law in France, what we see is a reliance on these tools to rate lawyers, which may decrease information asymmetry and need to comply with certain requirements. Be loyal, transparent, and clear to the consumer. Now, what actually does it mean to provide consumers with a loyal and clear and transparent information is actually one of the questions we are addressing in our research project, in particular when we are addressing rating mechanisms relying on IT or relying on new technologies. I'm going to walk you through that. And basically, we have ourselves implemented this project, which relies on a regulatory analysis, which I just presented. We've been looking at the different biases that have those information systems, those platforms within the European Union and abroad. And we are ourselves processing these information. So we have done data extraction and analysis in several jurisdictions with a methodology that I described there, but I will walk you through in detail right now. So what we look at first when we identify those platforms providing assessment of lawyers, and probably you're familiar with some of those, is that basically there is a clear move from what we could call reputational ratings to what we could call actually data-based or empirical-based ratings, meaning that if you look at those traditional actually platforms providing an assessment of lawyers, they were very much here based on surveys, self-reported data, peer review. Many of them were basically just reporting, let's say, the best lawyers, but not the bad lawyers. So it was very selective, and it was, of course, based on a very interpersonal discussion. Now, today, there is an emerging trend for legal analytics, and many of these devices rely on different technologies to extract data from different legal text and provide analytics about courts and lawyers, but also about courts, but also about lawyers. And so what we've done is we've analyzed many of these, the methodology of these platforms, and we've found several issues which could be contrary or at least pose a question in terms of loyalty. If we come back to the criteria of the Cour de Cassation in France. They could actually relate as well to be clear and transparent, but I will just focus here on loyalty to narrow down the questions. So what we find as different issues, many of them do not really take into account the lawyer's conduct, meaning many of them do not report any breach to code of ethics, which could be actually extracted from many legal texts. So a lawyer not going to a hearing, for instance. They don't take into account any jurisdictional trends. So the fact that in certain cases it is easier or more difficult to win a case, like at an appeal level. So of course the appellant is in a more difficult position to win a case. If you take statistics, you see that appellants tend to lose most of the cases at the appeal level. There is also a matter of granularity. So there is not enough information about the specialty of a lawyer that is practicing. There is not enough relational data, so accessing to a lawyer is not just accessing one lawyer, but accessing a lawyer in a context, right, in relation to other lawyers, to specific jurisdictions, to specific issues. Doesn't take into account labor distribution, so we know, and you know, that lawyers do not begin the case and end the case. There is a whole chain of work in a law firm. The person that prepares the case may not be the one that is pleading the case. There might be several persons involved in the preparation of the case. So there is that doesn't take into account labor distribution. And finally, there is very little on win-lose rate, right? And those that provide a win-lose rate actually do not provide any coefficient of difficulty. It is not the same thing to win to one of the easy cases that were presented earlier, where you have a title, for instance, as to win a difficult case. So our question is how to develop quality legal analytics at this stage, bearing on the framework that this might be used as a regulatory technology, if you want to put it like that, of the legal profession. So basically what we have done, and actually I'm a bit ashamed to present the results of only 3 months, because we've been conducting this part of the project for 3 months. But basically, we are extracting data from 4 jurisdictions, all French-speaking jurisdictions. And we currently have 2 different data sets. We have a data set of 126,000 and a bit more decisions crawled from the website of Legis France, which is a public service in France. And we were crawling about 2,000 documents a day. And we have also a second data set of around 12,000 files, so which in this case, HTML files, which were crawled through the laws. I'm going to not get into details of issues that have been there. So what we've done, first thing is we've gone through different processes, of course, of extracting information. First thing that we did was segmentation. So this is the process of decision in different courts by identifying identifying keywords in the decisions in an automated process. So this is automated extraction. There is no semi-supervised learning at all. And what we use in this case, what we did first was to segment the decisions and identify crucial entities for our analysis. Well, you might be familiar with that, but we use, of course, an R for identifying those keywords. So to give you a basic example, we use Polyglot, which is a pre-trained algorithm to identify, let's say, precedent, the word precedent. So we know that the nearest name to precedent is the name of the president of the court, right? So we extracted information in an automatized manner by using this algorithm that is already pre-trained and, of course, identifying keywords. And when it was difficult, so in case of president, we use one of the variants to identify the information. Then we came down to the decision, which was, we are still struggling a little bit with identifying the right decision, because I didn't mention that, but we all know that losing or winning a case, there's one thing about how difficult the case is, but there's also how you lose or win the case. I mean, you can partially lose the case or partially win the case. So this is also very difficult to identify. At this stage, because we are at the beginning and automating the process, we use the keywords confirm, rejette, irrecevable as meaning that the appellee won, or infirmer, rectifier, or réformer as meaning that the appellant won. In some cases, the words don't appear in the text, so those actually go to the trash right now. So it's still working out what's the best way to deal with it. Where did this lead us to? I'm gonna go quickly. How many minutes?
This is your first minute of extra.
Oh, my first minute. Okay, so I'm going to go quick here. So the first thing that we did is we identified what we call a network of lawyers, in which basically the width of the line identifies the number of cases they are dealing with each other. And then the red or the yellow, it's the net lost or won cases by that lawyer. So that's one of the first things. We identify networks of lawyers and judges. So we were talking about automating decision-making, but why don't you automate decision-making in relation to a certain group of clients or users of the legal system that have overload the system in this way, and you know the judges and the jurisdictions where they are going.
Criminal investigation.
Yeah. We also are coming out with what we call case difficulty coefficient. So we are trying to understand how difficult a case is, because of course this leads to different questions. So what we are using right now, we went through different trials, and what we are using right now is a clustering system based on the articles, the common articles that are cited, right? So if 3 decisions cite the same article of the civil code, then we cluster them. Then if they cite 5, then we started to identify what we call communities of cases. And when we apply this, for instance, to Cour d'appel in Paris, we see these communities of cases. And basically, these are all entirely automated, right? And when we go and look into those communities of cases, we actually see that those communities of cases relate to the same thing. So it might look a little bit weird here, but if we come back, this is the same stuff. If you come here and you go into there, you see actually the communities of cases, and if you go on top of it, you see the decision itself, and you see how it relates to the entire community of cases. Now, so basically, when we look at this community of cases, what is interesting is that if you see in this community of cases, most people have lost. So we assume, and that's how our working hypothesis, that it's very difficult to win a case in that type of cases. So if someone wins a case here, if someone wins a case here, you see, if someone wins a case here, it means he's probably a very good lawyer, because no one has able, so if he loses a case here, he's a very bad lawyer, because he hasn't been to win there. I mean, this is a very basic assumption, but that's how we are working on, based on just, this is, as I said before, we are clustering, and our manual, right now, our manual test shows that all these cases relate to the same issue. We might need to improve the tool, but we are at the very earliest stage. And then you hope you have a lot of communities where there is a very high losing rate, meaning, you know, most of the cases there are lost. Well, so that's basically, I want to stop here. We have, again, I mentioned this is a work in progress, but our idea is how to tackle and identify the technologies that are being used by these platforms that are delivering information to the consumers, and that the European Union might want to trust them, right? Might want to trust them as sort of regulators in the deregulation process of regulated professions. Thank you.
Many thanks. Very interesting. And now, instead of Katerina Zajc, Jaka Sepec, the floor is to Maximilian Gale, who is researcher at the Faculty of Law in Ljubljana.
Thank you.
Your topic is the same of the colleagues you have substituted. Thanks.
Dear colleagues, it's my honor to be here today with you discussing the topic of alternatives to existing insolvency proceedings. My name is Maximilian Gale. I'm from Faculty of Law, University of Ljubljana, Slovenia, and I will present the article of Professor Dr. Katarina Zajc and Professor Dr. Jaka Sepec. The article is about various alternatives to existing insolvency proceedings that could overcome the weaknesses of the present system. As a vital element in the institutional landscape of market economies, bankruptcy rules and procedures are intended to encourage the liquidation of unviable firms and to promote the restructuring of viable firms that are suffering from the contemporary distress. Whenever this objective is not met, socially costly filtering failures are set to occur. That's why one of the crucial questions in insolvency law is how to determine whether a company is viable or not. Different legal systems around the world use different models to determine the viability of the debtor. The common point of all systems is the decision-making is vested into people's judgment. Either judgment is vested to the court, to the creditors, or to the debtors. In each case, the decision-making process is biased by different initiatives of stakeholders and also by basic human error. That's why certain theoretical trends in insolvency theory have been looking for the alternatives to today's conventional proceedings that would overcome the difficulties in determining whether the debtor, in this case company, should be liquidated or reorganized. The alternatives can be divided into three groups: to public auction systems, to systems of ex-ante contractual agreements, and to theories of automatic debt to equity transformations. some of those solutions use certain methods of automatization, of automatization of dispute resolution. I will briefly present each group. Firstly, I will touch the subject of public auction systems. According to Bert and Rasmussen, the goal of law of corporate reorganizations is to provide a collective forum in which creditors and their common debtor define a future of a firm that would otherwise be torn apart by financial distress. Therefore, they conclude that the era of classical financial reorganization has come to an end. Instead of that, they propose selling firms as going concerns. Public sales are, according to them, the cheapest and the easiest model for solving insolvency issues, while they still ensure the main goal of insolvency law, that's collective forum or collective proceeding for repayment of creditors. The simplest collective proceeding is a sale of a company for cash and the distribution of the proceeds to all the investors. Debtors' assets can be either sold as going concern or sold piecemeal. Undoubtedly, the main advantage of this approach is the speed and the simplicity of the proceeding. But, however, it has to be pointed out that going concern sales are not without costs. That's due to the market mechanisms which don't perform well enough to produce the most effective result. The main problem is liquidity of the market, especially when medium-sized and large companies are being sold. The other problems related with public auctions are potential enormous costs of gathering and analyzing information, of choosing appropriate capital structure for the firm, and of the bidding process itself. This causes that only direct competitors will be willing to participate in the auction, but direct competitors will more often than not also face financial difficulties and will therefore not be able to possess the means required. For such reasons, public auctions would be the ideal bankruptcy procedure only in a world of perfect capital markets. Anybody who could make the company profitable would be able to raise cash from some source, for example, commercial bank, from investment bank, from stock market, and make a bid for the company. Perfect competition among bidders would also ensure that company would be sold for its true value. But with the fact that solvent sellers never decide to sell their assets through public auctions, Bauer proves that public auctions are not an effective system to sell the assets of a company. Or as he says, until the debtors are the best liquidators of their assets, the insolvency proceedings will be empty. The next alternatives are the theories of automatic debt to equity transformations. According to these theories, they try to implement some automatic proceedings which are based on automatic transformation from loan capital into equity. This automatization eliminates the need for judicial procedure and the need for agreements between debtor and its creditors on solving the debtor's insolvency. The main advantage, just a second. Yeah, the main advantage of those theories is that they practically immediately resolve insolvency and illiquidity. Consequently, the process is short, involves minimal costs, and furthermore eliminates the need, the problem of illiquidity of potential buyers. According to Babchuk, who is the main proponent of these theories, he argues that economics function must be separated from the potential disputes in the procedure in a way that the company of insolvent debtor can be quickly and inexpensively sold and delegated to the new company. The main problem of Babchuk's idea is the potential illiquidity of the creditors. They may not have additional liquid assets for call option. According to Hart and Moore, they believe that automatic debt to equity transformation are not optimal since they don't consider the conflict of interest between management and shareholders. Furthermore, They argued that automatic transformation gives false initiatives to the management of the debtor because the management will too often decide for carrying on the business despite the company being unviable. According to Bradley and Rosenzweig, they propose debt-to-equity transformations in a way that equity is firstly transferred to at least repaid claims. If creditors who become after the transformation shareholders are not able or are not willing to repay preferential creditors, automatic debt-to-equity transformation occurs. A fundamental weakness of the described procedures is that they don't solve the question of when the company is viable or unviable, and they shift this decision-making to the new shareholders. Theories of automatic debt-to-equity transformation basically force the new shareholders, actually the creditors of the company, to become shareholders and consequently become more actively involved in the company, even though majority of them does neither have interests nor the capacities for such activities. Due to that, Buffett in 1994 warned that automatic debt-to-equity transformations would be catastrophic in real life, since the banks would acquire the biggest share of assets, although they are not qualified for management of companies. That brings us to the third alternative. These are ex-ante contractual agreements. Generally, insolvency law contains mandatory norms. That means that creditors and debtors, they cannot contractually exclude the use of insolvency law that's prescribed by the state. Consequently, they can neither reach ex-ante agreement upon the choice of insolvency proceedings, nor change the rules regarding voting in financial reorganization proceeding. Many authors have, on the basis of Coase theorem, therefore suggested that insolvency rules should be limited in a way that they present only the framework enabling contractual agreements upon the parties. According to contractual theories, insolvency rules should be limited in a way so that they only present the framework for the parties. Hence, insolvency law should present only the basic framework for creditors and debtors' contractual agreements and legal provisions that would apply only when special agreement is not reached. Rasmussen therefore argues that each firm should ex-ante choose one of the possible procedures and incorporate it into firm statute. By that, potential creditors would get acquainted in advance with the rules that apply in each case, in case of firm's breach of obligations. And also Schwartz supports the idea of contractual model of insolvency proceeding as completion to mandatory system of insolvency law. He suggests the debtor could arrange with each new creditor the regime that will be applied in case of insolvency, wherein the regime stated with the last creditor would also apply to all the previous creditors automatically. According to more moderate supporters of contractual theories, for example, Warren and Westbrook, they argue that rules may stay as they are now, but it would be necessary to change their nature from mandatory to voluntary. And it can be observed that also numerous modern insolvency procedures follow this trend. The biggest issue of informal reorganization procedures is the fact that during the time of debtors and creditors negotiating about debtors' financial reorganization, a deferment of payment is not granted. Due to that, each creditor may claim enforcement and achieve preferential repayment. The management who entered the informal reorganization procedure, instead of submitting an application for the beginning of formal insolvency proceeding, which is prescribed in numerous legal systems as mandatory, is exposed to liability for damage and criminal sanctions too. So, to conclude, it can be observed that modern trends of insolvency law are aimed at the diversification of procedures that enable maximum flexibility in efficient solution-finding procedures. Therefore, the main goal of great majority of insolvency law reforms is to provide is to provide different financial reorganization procedures. Even though legal experts have been debating about these alternatives for almost 40 years, none of the proposed solutions have been widely incorporated in the current insolvency law systems yet. However, it's worth pointing out that the importance of ideas, of contractual theories and the theories of automatic debt to equity transformations, which have been discussed, are gaining in importance also at the national levels, because it's been observed that such informal procedures of financial reorganization and procedures that enable financial reorganization with debt to equity transformations are becoming progressively important and popular in practice. Thank you.
Thanks, Maximilian. Sharp. And now we put in brackets Marco Giacalone. He confirms he wants to skip the speech. And the floor is now to Lina Griškević. She's lecturer at the law faculty at Vilnius University. And she will speak about state of play of e-justice and potential of algorithmisation Lithuanian model.
Good afternoon, ladies and gentlemen. It is very interesting to take part in this conference with so many discussions and so many interesting topics. My 15 minutes will be very down to earth. It will be about state of play of e-justice in Lithuania and our model of e-filing system. First of all, what's Liteko? We have a courts informational system, Liteko, which was established in 2005, so now it's quite old, like an informational system of 13 years old. It's a very old informational system. And its main functionalities are related to the gathering and the usage of court process data. That means all the data on case, its parties, its materials, its documents, and its process. Then when you have this kind of data, you can store it, you can have some statistical reports, also you can have some search for documents, judicial decisions, etc. Nevertheless, you can also have some e-services that are provided for our society. One of which are electronic e-services. I'll speak later about recordings of court hearings and also about the remote court hearings. I divided our Lithuanian electronic services in 4 main spheres, one of which is already mentioned by Rimantas. It's e.teismas.lt. It's our electronic services portal, which is part of the Liteko. Then I'll present briefly e-case and pretrial investigation services, which we have from 2016, and then remote court hearings and recording of court hearings. The main milestones for introducing e-filing system in Lithuania was 2013 and 2015, when the legislation provided for e-filing system in civil administrative and administrative offense cases. Well, when we are speaking about e-filing system and using all the IT technologies, probably most of the users will say that it's very new, it's inconvenient, we would go for paper first of all. But then we had legislation that said that a certain group of people, a certain group of public authorities will have an obligation to receive documents in electronic form. That means that if you have an obligation to receive documents in electronic form, probably you will get used to deliver the documents to the courts also in the electronic form. So these groups are mainly the attorneys at law, notaries, bailiffs, experts, all public authorities. Then there is a list of cases which are performed only electronically. And the main rule which is set by the Judicial Council, is that if a case is initiated by the electronic document, then all the case is formed electronically and all other documents are either scanned or they are printed if a person is not a user of e-service portal. Also, if you have some obligations, there is a need to have some additional benefits for parties to use electronic means. And this benefit is a decrease of stamp duty. If you initiate a case in electronic means, you have to pay only 75% of stamp duty. So here you can see the interface of our e-service portal. It's a part, as I said, it's a part of Liteco. It's an application that can be reached by the browser. And interesting parties may access the portal using different means. It's e-signature, e-banking, identity card, or a password that is issued by the court. If a person don't want or doesn't have e-signature, ID card, identity card that's the modern one, or e-banking system, or doesn't want to use it. So he or she is free to use a password issued by the court. Then, if you want to start using our e-service portal, you have all the video assistance that's provided for you. Also, you have answer question sections, you have a telephone, you have emails where you can ask for some other questions. So we have some 6 main files, 6 main YouTube movies, which introduce with logging into the system, making a claim, uploading it, and having some mediation process also. All the parties that are using e-file system, we use it as, I like to say, as a Facebook account. Okay, you have a Facebook account where you can manage all the data you have. So first of all, you can form and deliver all the procedural documents. It means that you can upload them through that system. You can create your own documents. You can also store them for some later time. Maybe you don't have time to fill the claim today. Maybe you'll just start to do it partially, and then you'll finish tomorrow or day after. Then you also can familiarize with all the case materials. It means that all the documents that are presented in the electronic case will be digitalized, and you will be able to reach them from your house during your vacation or wherever you want. Also, you may listen to the court recordings, to the hearings that are recorded by the court. And here you can see the examples of uploading the documents and audio recordings. Also, you can manage payment of stamp duty. You may create a payment order, also receive a ruling of a court, and delegate the administration of portal account and appoint representatives. Usually this is used for and by the legal entities, the companies. A very good example of using our e-file system is judicial payment order that's processed almost purely automatically, except the digital signature of a judge still needed to sign. Imagine a father of family who is on his vacation and he decided to upload the request for judicial payment order. He paid a stamp duty with the help of a portal. He uploaded the request of a payment order via the portal, and within 2 days he has a judicial payment order issued by the court. And during those 2 days he can see and he can track all the process. He can see when the request was registered in the court. He can see when the judge was appointed in his case. He can also see when the judicial order will be issued, and he can download the PDF file with a judicial order. What's new when we speak about the e-filing system and judicial mediation, we have in Lithuania, it's the possibility for mediators and the parties of a mediation to connect and to communicate via our portal. They can make statements and claim or other document. Also, they can choose a mediator from the list of mediators. They can access the case. They can manage all the other functionalities that every user of e-filing system has. And also, they can have some discussions. As you can see here, it's a window, it's a space where parties can discuss some issues with mediator. Maybe they can arrange a meeting. Maybe they can arrange some other issues. And in order to keep the the confidentiality of the parties and of a discussion. These discussions were not stored for any other time. They disappear because it's very important to secure the confidentiality of the parties. Numbers. I like numbers. We have now we have 82% of users of our e-file portal. The percentage is more or less the same for a couple of years. Most of the practicing attorneys, they are users of our portal. Also, we have 1% of court mediators who are the users. And we have almost 70% of civil cases which were examined, which were resolved last year in electronic form. And it's 7% more than in 2017. So the number is increasing. Also, our system Liteko and electronic services, we have very many interconnections with other registers of a state, like residence register, property registers, and etc. And for example, last year there was almost 1 million requests from the courts in the cases to all those kind of registers. What it means that at least 2 million of paper sheets were saved, and at least 2 million papers were not used in order to receive some information. I'm not speaking about the time that should be used if there will be no interconnections between the systems. You know, when judge asks for some information from a register, he issues some document, he sends it via the post, and then he receives it back, so it would take probably a week or maybe 2 or 3 days. And now it's made within several minutes. E-case and pretrial investigation service. From 2016, the Ministry of Interior established the system of pretrial investigation service, and the aim of the system is to manage all the pretrial investigation process in one system. What it means that all the pretrial investigation institutions, we log into that system and they manage all the process in one system, from the police to the prosecution and to the pretrial investigation judge. Many structural documents are used there for policemen, for prosecutors, for judges. We can also upload all the documents that are already created outside the system, or we can use the ones that are created within the system. At the current stage, the system is dedicated only for pretrial investigation institutions. In the future, there are some plans in the future to open it to attorneys at law and also other participants of pretrial investigation services, so they would be able to make claims, to receive materials, etc. in pretrial investigation procedure. Remote code hearings is one of e-services, is one of means that help both the judge and, what's more important, for parties to participate and to save their time and energy in the judicial procedure. We can have remote code hearings both in civil, criminal, administrative cases. And as I said, I love numbers. I like numbers. So if you can see the increase of remote code hearings, so within the 3 years, we have increased from 239 to 1,503 remote code hearings in Lithuanian courts, and 12 international code hearings. In order to achieve this, we had to establish equipment in the courts. So all our courtrooms are equipped with stationary or mobile equipment that's needed for the remote court hearings. And also some institutions like pretrial detention institutions, they are also equipped with this kind of equipment. Maybe I'll just say that from 2016, there are no written protocols in civil, administrative, and administrative offense cases anymore. All the court hearings in these kind of cases are only recorded. All courtrooms are equipped with stationary equipment for recording of this kind of court hearings. In criminal cases, we still have written protocols, but all the court hearings are also recorded. And this recording also enables the parties of a procedure in civil, administrative, and administrative offense cases to access these recordings through our e-portal, e.teismas.lt portal. As I told you, our Liteko is very old. It's 13 years old and has a very old platform. In order to ensure the further development and sustainability of the system, now we're developing the new version of Liteko. We call it Liteko 2, though it's only a modernization of our current Liteko. It will provide us with new technology, new architecture of informational system, and new possibilities for data processes and for other solutions that are provided in the market when we speak about the IT and introducing new solutions of IT in our judicial system. Next year, from 2020, we also plan to have e-file in criminal cases. Probably we'll go step by step, not saying that all the criminal cases will be heard electronically or will be managed electronically. But we'll try to do it maybe piloting or having a smaller cases that are not so complicated, that are not so complex, managed only electronically. And when we speak about the modernizing, developing informational system, also using artificial intelligence or some solutions that are alike, probably we are also speaking about the user-friendly filing systems and user-friendly electronic communication that should be delivered by those solutions which are provided. So thank you very much for your time, and I'm ready to answer any questions you will have. Thank you.
Thank you, Lina. You two perfectly on time. And now the last speech of this session. It's Fabrizio Corona, who is in charge to speak about the application of fair division systems in cases involving the judicial division of assets. I think he will draw our attention back to the CREA project.
Yes.
Thank you.
Okay. Thank you, Vilnius University and Professor Rimantas Simaitis for the invitation. And thank you, Milda Margheritiucets, for the organization. The aim of the online dispute resolution is to resolve controversies and to provide a new improved methods of resolution with the same technical means on which these arise. The developers of the first online dispute resolution system had a tendency to imitate the dispute resolution channels in the ADR process in order to offer a valid solution that could also work online. Essentially, three reasons lead to this choice. The first, with the ODR systems, the users are unable to have face-to-face interaction. The second, the ODR system automatically records all the data of the dispute within their systems. And the third, user really on a computer for the solution of the dispute. So, one of the most important and most popular ODR system is Splitbit. This system includes a series of applications for fair division system. For example, there is the divide gods, the async creeds, and the share rent. Each application has a unique execution algorithm to guarantee an equitable distribution between the parties. So this is the algorithm split it to divide gods. And this algorithm considers two levels of fairness. The first, the envy-freeness. In an envy-free division, every agent feels that their share is at least as good as the share of any other agents, thus no agent feels envy. And the second element was the proportionality. Each player assigned up 1,000 points to divide gods. So in the Italian legal system, we regulate in Book 2, Title 4 of the Civil Code, the judicial division of assets. In this specific case, the procedure can be divided into the following phases. The first, according to Article 726, paragraph 1, the objects are appraised. After the appraisal, all the objects are divided into many portions as there are participants, according to Article 726, paragraph 2, and providing a cash competition where there is the inequity in a portion. At the lastly, the portions are allocated by driving lots. The procedure established in the Italian legal system, although impartial, very often does not satisfy most, if not all, the protagonists of said division, as it does not consider each participant's subject evaluation regarding the object at stake, since the evaluation performed by technical office consultant is merely economic. In numerous rulings of the Supreme Court of Cassation, the Supreme Court, on the subject are proof on this prior statement. In my analysis, I read three different types of Supreme Court of Cassation. The number 15466-2016, the number 13205 to 2017, and the number 18546 2017. The common data emerging from this ruling are three following elements. All rulings concern dispute that began between the ends of 1990s and the beginnings of the 2000s. And in some cases, the original plaintiff died and the heir took over. The second point is the creation adopted in the matters of judicial division, as well as the estimated of the assets to be divided, fall with the exclusive discretionality power of the trial judge, whose the evaluation are unquestionable. And the third point is in all these cases analysis, the parties did not obtain a division that satisfied them. So to verify the efficiency of the fair division system in a case of hereditary division, I ran the data of one of the three decisions, the number 15466-2016 in the of the Supreme Court in the split it. For this case, we should call three heirs involved to rulings, in particular Mario, Rosa, and Giorgio. And they must divide the indivisible assets that are parts of their inheritance to the three portions. In particular, we have 1/3 of the house side C, and for Mario, the evaluation is 200 points, but for Rosa it's 700 points, and for Giorgio 200 points. So 1/3 of the house side B for Mario 300 points, Rosa 150 points, and Giorgio 650 points. And for 1/3 of the house side A, for Mario is 500 points, Rosa 150 points, and Giorgio 150 points. After the elaboration, the split system gave the following results that guarantee the best decision of property among the heirs. And in particular, this is the result. The split system assigned to Mario 1/3 of the house said A, because the 500 points is the highest score were given by to the heirs, Giorgio and Rosa. It's similar to Rosa and Giorgio, because Rosa value is 500 points, 1/3 of the house side C, and the highest score given to Mario and Giorgio, and even for Giorgio. Giorgio value 650 points to have 1/3 of the house side B. So in this and in many other cases, the use of the alternative dispute resolution system would have guarantee in much shorter time frame an equal or higher level of satisfaction to all parties. Thank you.
We save almost 7 minutes, so we can give more time to the audience for questions and comments. Please.
Yeah, so I have a question to Dr. David Amoriles. I really enjoyed your talk, and it kind of reminds me of the efforts we have to text mine literature in medicine. So the question is really, have you had a look at the distribution of lawyers in terms of how do they look? Like, what's the gap between the superstars and maybe not so well-performing ones? And then how do you think this will help to maybe uplift the overall quality of law, or maybe it will just create a division between superstars and you know, the other ones? And I guess ultimately is, how would that affect the relationship between the client and the lawyer, knowing this, where my lawyer falls in this list?
This is for you. Superstar, you are a superstar?
Thank you. Yeah, very interesting question. Well, so far we haven't, but we've found some interesting results about those that are considered generally superstars and those that are not. So we have already some results showing losing and winning rates of some lawyers, which of course we've presented. By the way, we are not at all, first of all, we are not commercializing this. And second, this is a project that is conducted in partnership with the Paris Bar Association. So it is entirely supported actually by the lawyers themselves, which basically think that there is an interest in getting involved in this to sort of unveil what is behind what is done by legal texts, which are themselves doing similar thing, but for commercial purposes. But what I can say about your question, probably about the relationship with the clients, is that one of the things that puzzles us in conducting this project is we're kind of inquiring what information would be loyal, clear, and transparent to the consumers. We realize that that information may be too complex. So it's a bit contradictory in the sense that we're trying to kind of complexify the information to account properly for the job of lawyers, and at the same time this information becomes too complex for the consumer. So we don't know what's next, where to go with this information, as what is finally the defining criteria or criterion that a consumer might use to select actually his or her lawyer, and how this may change or not the behavior of the lawyers themselves. So I think that those are very interesting questions that unfortunately we're at a too early stage to address, but definitely I think are going to be relevant in the second phase of the research.
Any question to ordinary lawyers?
Thank you for your speeches. My name is Laurinas Totoraitis from Vilnius University. I want to address Dr. Griškevič. And this question is related to the first session we had in the morning. I don't know if you heard it, that the courts usually have a workload of 11% or so making judgments, while the other part of their tasks are like technical aspects. And the first thought to me that came to my mind was we have a court order or teismo įsakymas, which is also a technical document issued by the court. Is it so, or are you planning to implement maybe some automatization or algorithm, because we have a conference today on algorithm, to remove these tasks from the people working in the courts and maybe making it automatic? Thank you.
So it's working. As I introduced the judicial court order as a very good example, what we have now that we algorithmized, is because when a person uploads the request, the judicial order is composed automatically. All of the information from the request is used, and only the signature of a judge is needed. So until there is a need for signature of a judge for a document, until that moment we are we need the judge himself or herself to have some action to make in order to issue this order. Nevertheless, there are some ideas, because there are some very different practices in Europe how to deal with this payment orders, and there are maybe even some countries where not judge is issuing the judicial order. It may be transferred to bailiffs, for example, or other institutions. So this is the kind of solutions that would allow the judge to deliver or to dedicate his main time for adjudicating the really complex cases and difficult ones. If I answered your question.
You answered perfectly. Thank you. A follow-up one. Decision consists of many parts, and only one of them is the ruling part, while others are, summary of arguments. Is it possible to implement, and do we need to change the legal acts of Lithuania and other jurisdictions to do that?
I totally agree with your idea, which I can see through your question. Because when we speak about Liteco 2 and we speak about the further development of systems, it will not be possible, in my opinion, it will not be possible to develop further without having structurized court decisions. And they will have to be structurized more and more. Now we have maybe first steps, we have some standards of court decisions which are adopted by the Judicial Council. It's still only a recommendation, it's still only some main standards, main principles, but the trend in the European countries and also the trend within our pretrial investigation system is that there should be more and more structurized court decisions, and then we can speak about the structurized rulings, structurized motives, structurized introductory part, or even the resolution part. And then you can use this metadata, because then it could become a metadata of a court decision, and this metadata of court decision may be used in other stages by other institutions, like bailiffs, notaries, etc.
Rimantas.
I have a question. To Lina Griškevič, you mentioned the further development of Liteco 2. Yes, that's fascinating what we have already achieved. And a question to you, you mentioned, you noted that there are possibilities that maybe some more sophisticated tools will be implemented there. So we already have, by way, online dispute resolution integrated in Liteco. You have not mentioned it. We have online mediation integrated into it, which is quite unique. When we started to do that, it was also unique. No other court's information system has online mediation system integrated, but we already have. But my question is directly focusing at possibility and potential, as we discussed before in your process of preparation for this speech. How open, in your opinion, maybe not official opinion, but in your opinion, personal opinion, would be LITECO 2 open to allow integrating in the system various algorithms and various modern tools for support of judges making their decisions? Because, for example, now we're developing one of or several algorithms which might support mediators, judges, and whoever. Do you think that such systems, and in particular LITECO 2, would be open to integrate them if somebody, judicial council, parliament, whoever will tell, okay, let's do that? Or maybe you already have some plans, specific plans. Yes, you are planning, you are specifying such tools, and you are going to integrate in LITECO 2 in 2020.
Now we're only in a process of developing this modernization procedure, actually. It's not the new system, it's the modernization, it's only a new platform and new architecture, new informational system architecture, which will enable us to have a more sustainable system. Because if there are some attorneys at law of Lithuania, we know that sometimes our LITECO struggles with quick proceedings and quick processing of data. We are still open for new ideas and new projects that are coming. Also bearing in mind that our system is one of the most important systems in Lithuania when we are speaking about the systems that are important for state security. So also have to bear in mind this aspect right now more than ever. And there are some plans of integrating this system with some other systems also in Lithuania. But yes, we are still hoping and we are still looking for new developments. And our new architecture of information system will enable us to introduce more integrations or maybe introduce new developments and new solutions. Because now, probably at this stage, our LITECO 1 is at its maybe at the top of its abilities. So that's why we need the modernization.
I think that's a real challenge when you look at what happened by law firms with startups. They analyze our decisions. I'm a judge, more than you do. They are already connected to the decisions, and then they connect it to the judge, and they look which court is the best one to go with, judge is the best one, and the administration analyze our decisions. For example, I don't know the real word in English. I precede a court for Bebauungspläne. Is someone German here who knows what Bebauungspläne is? Bebauungspläne, plans for creating the environment in a city. Things like that, and they analyze our decisions, and they create their plans in advance, how far they can go. And we are still working like we did it years before, perhaps a little bit structuring the proceeding by algorithm, and therefore I think we have a real challenge as the court system to be on the same level with the lawyers or the business. They do the same. Well, they create, they found startups. In Germany it happens, in US it happens a lot. And I think, yeah, there's a challenge, and we have to do it and not to dream it or to fear it.
Yeah, just a comment on that.
So sure. I think law firms are kind of ahead of that. Well, actually, we also do this for law firms, and we collaborate with startups, and we have, this is just a specific project we are conducting on this specific issue of what constitutes loyal information for consumers. But we have profiling of judges and lawyers in France, so very widely as well, and we actually work in partnership with law firms as well. So, but what I think is quite relevant, and I just wanted to connect that and what you were saying about implementing any sort of algorithmic procedure or help for the judge based on any algorithm processing of information, whether it's automated processing of extraction of information. It's how free, to a certain extent, the judge remains to take a decision, in the sense that in the administration there is already some cases where we see that when the official is proposed with a solution based on automated processing of information, including machine learning, there is already an information overload. Many of the officials work in the context of public management. They have to accomplish certain targets. So it is very hard that an official challenges a proposed solution of a system that is based on machine learning, because it is very costly for that person to justify the challenge in that framework, in that just social, managerial and framework. So I think it is. I think this should not be disconnected. And law firms actually operate, and again, similar to what you were saying, in a similar framework. It is not just because they know which lawyer it's the best for this jurisdiction on these specific cases that they actually do send that lawyer, because they might organize entirely different the way they work within the law firm. So I think it is also important, the same reflection for the jurisdictions, is that it is not because there is some way, I mean, just to give you a very small example with the Cour de Cassation in France, with which we work as well. If you just defined a data set on the basis of which you're going to extract precedents, you may just leave aside a whole set of decisions that you are not using, and that in some cases judges themselves justify that it's not part of the data set for whatever reason, because they are not important, because they are not relevant, but still they are out of the data set. So how much are we living outside, but also how much capacity as a part of the system the judge has to deal with a system of algorithmic decision making is quite relevant, besides or beyond the system itself. So it's just yeah.
Do we agree about coffee now? Okay. And at what time do we resume? Maybe 20 minutes. 20 minutes, so 4:25. Okay. Thank you.
dear consumer, an online dispute resolution on consumers. So I would like to discuss it with you, 10 minutes about. If you have some ideas, you can start thinking about that right now, and then we can, at the end, discuss that. So we had some experience on that, and we had bad experiences. Why? Maybe there are people who are interested in this topic, quite a lot, and I will invite them here to present their mind about that. So after that, we have the conclusion of Professor Rimantas Simaitis and Dr. Marco Giacalone about our workshop. So let's begin with Dr. Linas Bukauskas, thank you, head of cybersecurity laboratory, associate professor at Institute of Computer Science of Vilnius University, vice president of nonprofit genes.com. So the title is The Case of Cybersecurity Law Description and Validation Using Unified Modeling Language. Please.
Good evening, ladies and gentlemen. I'm very proud to be here. So let me introduce myself first of all. So I'm Linas Bukauskas. I work at the Institute of Computer Science, Vilnius University. And I am, as introduced, head of cybersecurity laboratory, which was established quite some time ago. But I will explain today our research, we work on, or I explain research which we did and had some experience on using specific modeling language to describe laws or to describe some documents that would be legislative or some descriptive. So who we are, first of all, and cybersecurity laboratory is basically responsible for development of virtual and technological platforms for education. That's the first thing. And most of the time, what we do, our scope comes in for tabletop exercises. So it means that whenever we work with our trainees, usually we have several options to go for. One is getting hands dirty, meaning working with keyboards, or having some tabletop exercises, which is just having documents. And documents is usually laws, various types of consequential derivatives, and even organizational standards. So also we have cybersecurity range infrastructure where a number of people can fit in and train themselves to be hackers, or vice versa, to become not hackers but defenders of infrastructure. So also we work on tooling and digital forensics in data protection. And also the most and very most interesting for us, because we are a university at the end, competence assessment and evaluation. So how do we assess whether people learn something? How do we assess and evaluate whether our trainee got some knowledge or got some experience in some kind of cybersecurity? So everything started as Lithuania adopted cybersecurity law 2014, and in 2015, we started organizing together with Ministry of Defense special exercises where papers were tossed around saying that, oh, this is a cyber incident. Now what will happen? You look at the document and you look at the law, what you have to do, you look on other documents, and then you decide where do you go, what to do, and so on and so forth. So basically, we had this kind of session where no computers are around. Only pile of papers, pile of documents, and of course heads. And of course it is most of the time organized for people who are very in the top management, or they are basically decision makers. And the next part of the trainings was for those who are technology people. Okay, so I'm a computer scientist, and I'm very keen of working with computer science people, and suddenly, when you think these guys, they have computers, and ladies, they have computers, we work with computers, we do a lot of stuff, hacking stuff, and the previous one, we just didn't do anything with computers. We did only kind of paper paper shuffling. So is it good or bad? I don't know, but in 2018, we kind of managed to do a hybrid exercises, and hybrid exercises where tabletop together, meaning that legislative documents together with exercises that are technical exercises, together with computer scientists or with those who are technicians, we were merged together and we managed to kind of speak some language. And I'll explain how we did it and how we try to foster this in future. So first of all, let's look into different views. Management view, or the legislative people, those who are working in kind of in decision makers, those who try to influence security of the organization. Usually they say that there is a misunderstanding of security. Basically, we are secure because what? You are secure because of what? You kind of feel it, yes? You just say, I have updated software. I have newest passwords. I have something. What is it? What it is a security? What is a DDoS? What is a Trojan horse? What is a, whatever, crypto locker, virus? A lot of decision makers, they just didn't know, or decision makers, they didn't know the kind of consequences certain technological cyber incidents may have impact on. Also, sometimes when we start exercising and when we start, doing these tabletop exercises, management becomes lost in action. Why? It's because it's a lot of regulations. It's a lot of kind of rules you have to remember. It's a lot of things you have to kind of know where to contact, who to call, how to write it down. And it was a bit it was a bit strange for those people who were trained, and it was a bit difficult for them to comprehend sometimes technological things inside of training kind of injects. The lower personnel, those who are in IT, those who are doing actual defense, also misunderstand the security. They usually think, well, my boss does not understand. I tell him, I need money for this firewall. I need money for this. But we are secure. Also, these technology people, they easily get missed in action. It's enough to run a DDoS attack, or it's enough to run a small virus on them, and they are totally missed in a computer. They are just inside of a computer. They're doing 100% in action. And then no legislations are there, because no legislation in ahead, no kind of contacts in ahead, what to do next. No one knows what to do next. And usually it becomes ad hoc kind of solution of cyber incidents. The easiest question would be, what would you do if you would switch off your phone? Do you remember any phone you want to call? Do you remember your boss's phone? Of course not. No. So that's the simplest question with cyber. Basically, if you take out some systems, some part of people, they are completely unable to call anyone, or they don't know where to look up locally on their computer because internet is disconnected, everything is disconnected, they don't know what to do. So what we did is, we kind of, how do we meet each other? How do we meet those who are doing, know these regulations, and how do we teach those who are actually doing defenses, and how do we teach those who are doing legislation or doing decision making so that they understand something from cyber incidents, or they do understand something related to technology. So what we did is basically we kind of churned out, based on a cybersecurity law and all other derivative documents, we thought, let's have some actors, let's have some structure. That would be the first thing. Like cyber incident management and investigation groups. In Lithuania at that time, in 2014 and 15, 16, it was like national CERT. It was a police, data protection unit, inspectorate, and that's it. And nothing, no one else. Yeah, these were 3 organizations. Now the question would be, if incident occurs, do I call them? And on what kind of incident, if occurs some kind of incident, who do I call to? the police? Or do I call CERT? Or do I call someone which is for data protection inspectorate? And then suddenly it becomes very clear that, you know, if you kind of make these layers of actors that are associated in within the role play of the whole legislative document, like strategic handling group, governmental management and communication group, managers of critical infrastructure, which is, by the way, the most important part of the document, service, like, you know, those who service providers, hosting providers, third parties that are kind of taking part within providing services, and also civilians, just regular people like us. So if we structure in the way this, kind of in this kind of pyramid, and say that, okay, all the most important things that happen, they should happen in the event of cyber incident, they should happen in cyber incident and management and investigation group, 3 organizations, then suddenly we have to think, how do we train people, and kind of based on our legislative documents, how do we kind of look up them? How do we help them? So what we did, we looked into unified modeling language. I don't know if most of you are familiar, but there is in computer science, there is unified modeling language, which allows to draw some kind of generalized schemas for sequences. Who do you communicate to, which is the most important part, and also actions to be taken. In what sequence, or it's called action diagram, what kind of set of actions you have to take, what if something happens, what is next to be done. So it means we took sequence diagrams and action diagrams and kind of tried to model what happens from cybersecurity law perspective. And we end up with this. So of course you cannot see it, and I'll show later on. So it was 2 meters by 3 if you print it in human readable form. It's a big sequence diagram, who communicates to whom, and of course it includes not only national cybersecurity law, it includes also underlying documents. But the idea is that you see this kind of communique that is going from one party to another party, from left-hand side to the right-hand side, or from right-hand side to the left-hand side. This is information that is passed. Not only that, we kind of associated that to legislative document, which kind of specific, you know, legislation, or what is the kind of paragraph of a law it refers to. And we ended up with, you know, with smaller pieces. Since we had this big diagram, we could just go for cutting out some small piece, generated smaller and smaller and smaller, depending on where you are in the cyber incident. So what we did, we created a machine-readable and programmable view where, sorry for Lithuanian, so it's for Lithuanians, but let's say we have a critical infrastructure. We have National Cybersecurity Center. We have RRT, which is National CERT, Police, Data Protection Inspectorate. So it means there are some, in the event of update of cyber incident, where you update the incident, you do communicate. And this is only the piece of, you know, the small fraction of the communique you do among or between several or among many organizations. So what we ended up, we added also action diagrams that were showing, okay, if something happens, then do that. If something happens, do that. If something happens, do that. If not, if yes, then return back. So what we were thinking of is, and now I'm going to, how do we meet each other? Meaning that once we explained this to those who are in decision making, we said, okay, instead of these 2 by 3 meters, you know, big wall, paper wall, you can see based on where you are, who you are, and where you are, we can show you kind of what you have to do and what sequence, in what sequence you have to do. And we ended up with some special system where you are designed like, you know, who you are kind of, What is your role? Is it a critical infrastructure? It shows the activity UML, what you have to do. It shows who do you send to. And also it kind of refers to the actual law or to actual procedures you have to follow. And that was during the teaching only phase. So this is only for teaching phase. In order to verify that you learn something, it means we teach you, you get an example of cyber incident, and it shows that, okay, based on this incident, you have to do this and that and that. Okay. Then the person tries to do that, and then we already evaluate the person. We switch off this help. And then, believe it or not, but like 70% approximately 70% of those who didn't have big experience in legislation, in reading law, in reading some, consequential documents that are derived from the law or organizational standards, they kind of learned much faster. And the idea is that after you kind of go through this process, you kind of end up with a system that helps you to kind of teach people. So, and that helped us to meet each other. And that was my experience. Okay, thank you. So if you want, I can show how does it look like the true one. The big document, it's only also a fraction for critical infrastructure, or for, okay, let's show for national cybersecurity centers. So this is, so can we zoom it? So how do we zoom? So if we zoom, it's like, we have, sorry. So basically, we have like on top, we have actors like Inspectorate of Data Protection, the police, we have national cybersecurity centers. And all these say that during the 30 minutes, you have to tell about cyber incident. It means it's one way. It means you just have to tell, but you'd never receive back anything. So what we did is basically we looked into this, we draw this diagram, and after exercises, I think now National Cybersecurity Center glued together with National CERT, so RRT, that was previously RRT. Now it's glued together as instead of 3 actors, now we have 2 actors that are managing. Instead of 4 actors, now we have 3 actors that manages cyber incidents. So that's kind of a good thing for us. So, and also if you go further down, you can see that, okay, each of these. And the idea is that you can project in various types of, you just say, okay, I am in this state. I would like for actor critical infrastructure, show what do I have to do. And then it just show who do you send to, what actions do you have to take. And once, if there are some kind of documents that are organizational-wise adopted, if we encode it, we can have it also here. So basically, the tool allows us to kind of dynamically teach students or trainees who are working with critical infrastructure, with some other infrastructure you want to defend from adversaries, to respond much faster. Now we know, okay, I have 30 minutes to do that. I have to look up there. And sometimes even people, they just print it out. Okay? So this is 3 by 2 meters of okay, how do I?
Thank you, Linus.
Yep.
For your enlightening speech. I would like to invite Mr. Sacco. Mr. Francesco Sacco is participant contact of the Bar Association in Rome for the CREA project. His speech is about ODR and algorithms. This is you. So please.
Thank you to all, to University of Vilnius, and I want to start this presentation. Our algorithms can help digitalizing, and the relationship between ODR ODR and algorithmic decision. First of all, I want to start with an historical introduction, because when we talk about justice, one problem is the causes of popular dissatisfaction with the administration of justice. This problem has been addressed since 1976 in the USA during the Pound Conference, and the solution proposed was the alternative dispute resolution. These methods, this solution can be defined as a setting or a collective description of methods of resolving disputes otherwise than through the normal trial process. The aims of the alternative dispute resolution is cost-effective, fair solution, time efficiency, and better solution for cross-border disputes. It is important to underline that it's just another way to resolving disputes. It doesn't preclude effective judicial protection. So, in particular, the European Union gives a specific fields of intervent in these big field of alternative dispute resolution as the commercial relations. The aim was to give consumers greater access to consumer protection than the position of advantage, in premise economic, of the business operator. So we want to respect the commercial relations. And the principle at the base of this system was of efficiency, transparency, and economy to the benefit of the consumer. In this regard, the directive of the European Union in Italy was received in three main lines. The first, a joint conciliation, or in Italian, conciliazione paritetica, which has become established in practice set up by commercial operators as a means to which the consumer could voluntarily have access in order to obtain a possible conciliation solution to the dispute. The second, the creation of ADRs established and regulated within the supervisory authorities and regulation of specific economic sectors, some with conciliatory outcomes, others awarded. And the last one is the Chambers of Commerce with reference to consumer disputes in which to operate as a civil and commercial mediator. This presentation wants to focus on the second type of ADR line, if we could call, and I want to explain the Banking and Financial Ombudsman, or the ABF, Arbitrato Bancario Finanziario, set up at the Bank of Italy, pursuant the Article 128 bis of Consolidated Law on Banking, introduced by the Investor Protection Law. The aim of this authority is to resolve disputes between consumers, natural person, or also, or also financial intermediaries concerning banking and financial transaction and services. According to the last resume of the ABF, this instrument works, and it works a lot. there were the 42% more complaints submitted, with the most recurring theme being the relating to banking and financing operation on the granting of cessione del quinto, an employee loan repayment unique in Italy, with the specific reference to the request for reimbursement of expenses incurred by the application and not accrued in the event of early termination of the relationship. How does it work, this process? Consumer submits a prior complaint to the intermediary. If intermediary doesn't respond, consumer lodges a direct appeal with the Technical Secretariat of ABF. There is a preliminary investigation. After refers the matter to the ABF's court, independent and impartial, and at the end we have the decision of ABF. The efficiency of this instrument lies in the strong consideration that the Bank of Italy enjoys in the financial sector, which also operates as the Italian supervisory and control authority under the single EU supervisory mechanism. The cessione del quinto is a specific case I analyzed, and with the specific reference to the request for reimbursement of expenses incurred by the applicants and not accrued in the event of early termination of the relationship. The financial intermediary who provides a loan is entitled to withdraw a portion of his salary or pension directly from his employer or pension institution. However, this is a contract which is advantageous for both parties, but also considerably costly for the consumer, who has to bear very high ancillary costs in full and in one go. So the consumer has the right to early repayment at any time of the amount due to the lender, and in this case is entitled to proportional reimbursement of interest and cost due. It turns to this ADR, precisely in order to have the congruous and proportional reimbursement of what, according to doctrine and jurisprudence in Italy, are commonly defined as recurring costs recognized. In particular, the Ombudsman is called to quantify this reimbursement, and does so by applying a criterion, namely that pro rata temporis, which values the time when the extinction took place. The financial intermediary who provides a loan is entitled, no, this is a repetition, yes, of course. No, because I'm going behind, and this is the data about to prepare the algorithm. We have the F with the loan, the R are the number of total installments, the U is the single installments, where the single amount required, the S, plus C with A, C with B, and C with V, the fee, different fees, and the P is the number of installments paid. So we are all this operation to obtain the total amount due from the financial intermediary. In this procedure, in most cases, the consumer raises as the subject of the dispute the claim for reimbursement of the cost of fees and life insurance signed at the time the loan was taken out, calculated and paid for the full amount. In the event of a preventive excision, in fact, these amounts are due in proportion to the installments already paid and not for those to be paid which have now been extinguished. In mathematical terms, this criterion means that the amount of each of the reimbursable cost items must be multiplied by a percentage of the loan repaid in advance, as resulting from the ratio between the total number of installments and of residual installments. No, okay. So we can see another theme what I have say before, and now the resolution procedure described represents a computational process. This concept, which may seem exclusively mathematical, may instead also be reflected in the legal world as seen above. It is based on two elements. We have the algorithm establishes the logical rules to be used in solving a problem, and the sequence according to which they must be applied. And after we have the coding commands, the coding, which commands the execution of the steps of that sequence on particular calculation device. So in this way, we could change the A of alternative dispute resolution in algorithm dispute resolution. In fact, we can divide the algorithm as a finite sequence of readable, repeatable, and unambiguous instruction. And the following characteristics are finished. The algorithm must lead to the solution in a finite number of steps, as the law. General or collective, the algorithm doesn't solve a single problem, but a class of problem, as law 2. Repeatable. If the same input data is given, the algorithm will have to give the same result in output. And also in law, we have this situation. And at the end, unambiguous, the indicated instructions are specifically unique, so that they are always executed in the same way, regardless of the executor. About this point, maybe we can have a question. What about the interpretation of the judge? But I want to answer that question in the end. Besides, we can start with the legislation to make computational the law. In fact, some authors, Lessing, he speak about code is law, or better, code is the law. So, code translation of law, keeping in mind the logic underlying the legislator before analyzing the procedures. A first step for me could be the algorithmization of some specific procedure to ADR process as the algorithm before, where the logic behind it's simplified by the purposes of this process, and where the object of dispute are material goods, mostly recoverable in an economic value. The use of computational thinking must be placed at the center of attention in ODR procedures, of course. ODR procedures, online dispute resolution, are an evolution of ADR. Also, the European Union, with the advent of the single market, changed the community policy, opening up to the digitalization to protect citizens or consumer. With the Directive 31 of 2000, already introduced this system. This phenomena a necessary development of ADRs. These alternative dispute resolution tools are the reason for their relationship with the digital world, in particular with the world of the internet, the online world. It's a dispute settlement which may or may not involve a binding decision being made by a third party, implying the use of online technologies to facilitate the resolution of dispute between parties. It's possible to divide ODR in ODR of internet as a space in which a dispute emerges, unfolds, and is defined, and also an ODR by internet as a tool through which a dispute is resolved. The regulation on ODR for consumers, which has also set up the related web portal through which it has contacted the ADR tool suitable to resolve the dispute, or where consumers can resolve the dispute. But a sine qua non for using this tool, among others, is to have made online purchases of goods or services by a trader established in EU as a consumer. Stop. Some dispute could be the subject of analysis and implementation on a platform such as ODR, as the previous example, resulting in algorithmic decision. In this way, the claimant could be put in a position to settle the entire dispute directly online, optimizing the use of this procedure, relying on system with perfect rationality. So, okay. By the way, the big step is resolution of cross-border disputes involving available rights, because now we had talk just for goods, economic goods. So, in this way, I suggest that for a better EU justice, we have to use ODR and algorithmisation. And to answer at the previous question about the interpretation of the judge, in any case, the traditional trial is guaranteed by a trial. So we don't have problems, in my opinion. Thank you.
Sorry. And now I will invite Dr. Ellis Temeli, postdoctoral researcher at Erasmus University, Rotterdam, and Mr. Stefan Philipsen, assistant professor at the University of Utrecht. Perceptions of AI as a judge in a civil and family cases, empirical findings. So please.
Let me start by saying good afternoon, everybody. It's good to see that still this many people survived the day. So many brave souls in the room. Let me also start by saying that it's great to be here. It was a great conference, I think. I heard a lot of interesting new insights that I will take home. And I want to thank, we would like to thank Rimantas for organizing this conference and Milda for being such a great host. Our presentation, this presentation is a presentation in 2 parts. My colleague, Alice Temeli, will take the second part. Alice is a postdoc in a ERC project led by Professor Kramer in Rotterdam, which is called Building EU Civil Justice. And Alice focuses in particular on digitalization of justice. Me, myself, I'm a assistant professor in constitutional law. We used to work at the same university, but I now work in Utrecht. What will we present today? What we will present are the preliminary research, the first results of a empirical research we conducted together with colleagues on the question, how do people perceive, would people perceive the use of AI in state courts? Basically, we gave them 2 options. You can either have a situation in which a human decides your case or AI. We often use this picture that is projected here. It's the nightmare of everybody, but it's always a good starter for discussions. Here you can see roughly what we will do. I promised the organizers that I will keep it short and within the time, so I will try to do that. Now, how did we start and where did we start? The involvement of Alice makes sense, of course, because of the ERC project. Me, myself, I always worked in constitutional law and administrative law and was confronted about a year or 2 ago with automated decision-making in administrative law, which took, in particular in the Netherlands, a big flight. So a lot of decisions, even in what we would call administrative criminal law, are taken by computers. Without people, and it has been mentioned today, without people really perceiving that as a problem, and it was interesting to me, why would that be the case? Why are people so easily accepting the fact that a lot of government decisions are taken fully automatically without a person even being involved? We got a small grant from our university, and then we combined the insights of different disciplines. We had, of course, the law insight and discipline, but also the ones of management. Our colleagues, Professor Stefano Potoni and Gisem Yalcin, are specialized in man-machine interaction in the field of consumers. So there, a lot of research is done on this topic, man-machine interaction, and we try to take these insights into the field of law. Into the field of law because we had, when we dove into this topic, we had the idea that there was a problem. In the legal discussions, the discussions were mainly focused on 2 aspects. First aspect, practical considerations. Is it possible? Is it factually possible to make an AI that will be able to replace judges or part of what judges do? And how would it work? Second problem, legal problems. Yeah, this is mentioned today. First, the human right problem. Secondly, for example, impartiality. A big problem when it comes to the use of AI by government institutions. Most of these algorithms are developed by private actors. The government doesn't have the specialty to make, develop, and really understand the AI. Can we accept that when it comes to courts, judges who are meant to be impartial? So these legal considerations and practical considerations are very, very important, cannot be stretched enough. But a perspective that we thought was undervalued in this discussion was the question of how would people perceive? Would people be willing to accept decisions taken by artificial intelligence if that artificial intelligence would be used in court situations? We see that they are willing to accept it in other fields of law. but how would it work? How would it work in courts? And would it especially influence their feeling, their perception of justice? Now, how to research this? How to research this? When you want to know how does the use of AI influence people's perceptions, we picked a starting point, and the starting point could possibly be two ways. First of all, you tell people about the different tasks a judge has, and you automate one of these tasks. It's one opportunity. So you say, let's say your judge used for his jurisprudence research or for analyzing the documents of the parties, or you can differentiate all the steps. AI, and what would you feel about? We went for a more broader, more bold approach and said, no, what we want to do first in this explanatory research is to go to the extreme and offer people the possibility. One possibility is there's a judge that is a computer. You file your cases to a computer, and your computer decides you don't see a human. The other option is the classical way of a human deciding. The classical way of a human deciding. And the questions we had there were threefold. First of all, does this situation in which we have AI or we have a human, does it influence the people's willingness to put their case, to submit their case to court? Does it have influence? First question. Second question, what if you present people with the fact that their case was decided by AI, how does it influence their trust in the decision? Second question. And thirdly, we wanted also to test whether the advantages that are always put forward in using AI, it's cheaper, it might be faster, it might be more objective, etc., etc., whether people take these advantages in consideration when judging the use of AI in courts. So these were our three questions. Are they willing to submit? How does it influence their trust? And what's their perception of the advantages put forward on AI? And then we decided to investigate this for two types of cases. In the morning, the first presentation, Dory Riling discussed different sorts of cases, and for one case it seems more feasible to use AI than for the other. We took two kinds of cases. We had a divorce case, a family law case in which people had to divide goods, and the other case was a consumer case, a car that broke down, and a consumer suing the car dealer. These two cases, and the difference between these two cases, of course, is that the family law case always has some sort of atmosphere of emotions being involved. That it is not less directly involved in the car case. And what we did then is add layers of complexity and see how, by adding layers of complexity to the case, whether that influences the people's willingness to submit their case, their trust, or their perception towards the advantages. And we picked two types of complexity. The first one was human complexity. So we, to put it very simple, we made the case a bit more sad, and the other one was legal complexity, mainly in the number of documents involved, and other, let's say, more legal aspects of the case. We added them to see whether that would influence the case. I think we go now to the second part? Yes. Good.
I'm Eristemeli, and I would like to thank the organizers for having me, and also to thank all of you that are brave enough to stay until the end. I'll try to be brief. So Stefan presented the outline of the empirical research. I'll go a bit more into details of about the methodology, so we know exactly what the findings actually bring afterwards. So as respondents, we use Mechanic Turks, which is like a service of Amazon. And well, it's not really, that is not the respondent, but it's like, yeah, Turkey. So practically we have two cases. One is the divorce case, one is the car case. Each case has different, is presented in its simple version, then its human complexity version, and factual complexity version. Respondents get only one case. They don't know what is happening with the other cases. We want to isolate them so they don't know what is behind the study. We want their genuine answers from them. So practically for every of these situations, we have more or less 300 respondents. Well, you can see that in the divorce case, there is that is the total number of respondents, and that is the total number of respondents in the car case. The respondents are US citizens, so take this into account because according to the jurisdiction, we might have different results. We asked about age, income, ICT expertise, so they had to tell themselves how comfortable they feel with ICT. Court experience, because we considered these two elements as important when you think about artificial intelligence or a judge. And then respondents, after reading the case, they were presented with a series of, well, they were asked, how much do you think the judge will be fair, trustworthy, predictable, biased, fast, and expensive? They have a Likert case, and then they had to pick where do they see, what do they think. So you see that we try to test a bit what the literature claims that artificial intelligence, but also human judges, bring or have different from each other. We asked also people about the level of negativity or the level of rivalry in between the parties, because we consider that also the rivalry in between parties might be influential in their willingness to send the case to an artificial intelligence judge or to a human judge. And then in the end, we asked also the most important question: how willing are you to send this case that you just read to this particular judge? So they had, according to the random case that they were assigned. Well, before this, I have to make also this disclaimer, which is important for our colleagues that really carried out the survey. The survey was pre-registered, meaning that, well, it's like a kind of quality mark that you have to claim beforehand what you are going to do, what are your what do you want to find out, and then carry out the research. The first step we did is we carried out the divorce case with 400 respondents. The results did not provide, we didn't have significantly statistically significant results. So we repeated the case again for the divorce case. The results were statistically significant. This does not mean that we were pushing towards a certain direction, but still we wanted significance in our findings. After this, we repeated the same experiment with an amount of respondents for the car case. Now, I mentioned that we had several levels of complexity, which was our theoretical assumption. Then we asked the respondents, and that was one of the first questions: how complex did they think the case presented to them was? And that was clear, statistically significant, that cases that had a human or a factual complexity were indeed complex, regardless of the kind of judge that the respondents were assigned. And this complexity was equal in between the two types of judges. When asked about how do they think that the case will be complex according to the judge, the situation changed. Of course, the complexity increases by the type of complexity that we provide, where the human case is less complex than the factual case, but more complex than the simple case. But for the artificial intelligence judge, the cases are considered more complex than than for the human judge. So now you can see also where this goes. So for the human judge, the cases, respondents consider the cases to be a bit less complex. Now, the second important question that we had, which also Stefan mentioned, was about the trustworthiness of the judge. So practically, it's something that we often stress, that regardless of how advanced artificial intelligence and these systems are, if they are not trusted, people will be reluctant to send these cases to these judges. Therefore, the effort of governments, but also developers, will be a bit in vain. And this trust is also nice to compare also with other jurisdictions, as it was mentioned in the beginning of this session. But we found out that trustworthiness was important for the type of a case. So if the case was simple, the respondents trusted the judge more, then the trust was decreasing, regardless of the judge. So even if the judge was human, the more complex the case, the more trust was falling. And it was falling. It was the respondent has less trust in cases where the complexity was in the human factor. In both these cases, artificial intelligence was trusted less than the human judge. So this is also this can be related also to the complexity. Once you think that the case is too complex for a certain judge, you also think that, well, that judge, I'm not going to trust that judge in the resolution of that case. On the positive side, for the artificial intelligence judge, all of the respondents, and quite significantly, consider this type of judge as faster, but also as cheaper. And this is has an importance which I'll mention in the end. Lastly, we asked them how willing would they be to submit the case that they just read to this type of judge that they were assigned. They were more willing to submit the case to the human judge, considering also the perception they had about complexity and trustworthiness. But they were more willing to submit it when the case was simple than compared to when the case becomes more complicated. And that becomes statistically significant if we compare in between artificial intelligence judge and the human judge. But in between the same type of judge and different complexities of the case, the statistical significance in between the different type of cases becomes less significant. To sum all these findings, we may say that people seem to be a bit reluctant to submit their cases to an artificial intelligence judge. Well, what does this mean? Do we need really to discard the idea of having an artificial intelligence judge or not? Things that should be considered here is and these are also what we would like to find in the future. First of all, we would like to test this same experiment in different jurisdictions. We are aware, that in certain jurisdictions, the quality of the court system, the quality of judge, but also the availability of the judge himself, it is not so good. So it can be that the population in that type of jurisdiction might be more willing to go to a judge, to an artificial intelligence judge. On the other hand, there might be also a difference in between the type of cases that are presented. There might be cases where people would appreciate more speed and the procedures being cheap, rather than the other elements like trust or a perceived complexity for the system. So as to say that if the case is simple enough, the parties don't really want to bother with a complex human court. They might prefer an artificial intelligence judge. This would be something that we would like to consider for the future, to find for certain jurisdictions or certain situations where this tipping point of the balance would be. On the other hand, this type of studies, which also this conference is about, is very important for policymakers as well as for the people. As I said at the beginning, unless we are sure that the population, the court users, are going to use these new technologies, it might be a bit unwise to deploy them. With this, I'd like to thank you, and if you want to have, if you have questions, please, these are our contacts, and thank you.
Thank you. Erlis and Stefan, I think question after. I have a question too, but after Mantas Medelis, CEO, founder at Token.me, UAB, realities of language processing business, finance, industry.
So good afternoon. I'm the last one, I guess. And from the previous speakers, I understand that I will be giving slightly different perspective, not from the academia, but from the trenches of a business. Finance industry. Okay, I'm founder of the Token Mill. It's a language processing company. We are working for about 8 years in all sorts of text processing tasks. Basically, when you want to understand the text, extract the facts from the text and process them. So law is actually the area where you deal with the text everywhere. Contracts, court proceedings, and so on. But from our perspective, from our experience, we are mainly working in finance because, and it's due to the law business is structured. I think it's much more conservative and less vibrant than finance. We had a few steps at finance, at law projects, but it's just very hard to overcome the conservative nature of the law. Okay, so, but I hope that at least some of the points from the financial industry will be quite applicable to what's happening around broadly around law. So one of the major areas, major issues we're facing when working with clients, with anyone who wants to process text, is that it's very hard to explain how difficult it is. For us, for humans, it's so easy to understand what I'm talking about. I hope that you understand, but for the machine, it's totally different world. Like X was fined by Z. Yeah, the company selling cars was fined by the regulator for violating certain laws, competition laws. We immediately know who is the victim, who is the criminal, and who is the persecutor. For the machine to understand those relationships, it's so hard. So when you estimate the project, you estimate the need, the amount of work you will need for that, the eagles, that is us, will say, come on, I can raise my family on the branch and feed them and this and that, and you need this runaway concrete thing, and then the cost is totally unacceptable. So kind of this, and the hype around AI we are currently seeing doesn't help with that. Because now everybody thinks that AI will do some magic, and bam, we have a solution. We will have the artificial court, artificial guy who will solve the divorce cases. So this kind of a perspective mismatch, expectations mismatch. It was always a problem in IT, but with AI, with language, it's close to non-manageable. That's why probably you never heard about any unicorn company that is making more than $1 billion in a language processing area. Okay, so just a few of the kind of the more concrete things. So one of the biggest misconceptions is that we have this generic model like Facebook on the here would fire, you know, a big PR campaign about saying, okay, we have a new language processing technology. Or university would you know, announce that, okay, we have a wonderful technology which will solve everything. When in fact it is trained and works only with Wall Street Journal's articles from 1990s, because the licensing allows them to read only from that small portion. So again, you would see misconception between what is actually available in terms of training data through Mechanical Turk or through whatnot, and the reality of actual documents, its audits, or court proceedings or whatnot. So usually you would have language models trained on news, and the reality is that you are dealing with documents, totally different thing. For us, we don't even, sentences read the same, yes, for us, more or less, be it from BBC or The Guardian, and the sentence on the audit, it's kind of the same. We don't even notice the minute differences. But for the machine, it's so brittle that you have to retrain, and again, back to the first slide, costs. Yeah, and I'm happy that it's back to your one of the themes with trust. So in finance, we do a lot of the small court decisions. If I do a transaction from my bank account to your bank account, there will be a system which will monitor that transaction and decide, is it valid? Is it anti-money? Is it good kind of a transaction, or is it kind of money laundering potentially transaction? Maybe you will send. If you will send money to Pakistan, it will be immediately blocked because there is a rule. And the regulator, the central bank, would always, at least now, this is the situation, will reject any AI-based solution because you don't know why my transaction was blocked. Why? It's blocked. It looked like it might be for a valid reason, for reasons for AI, it might be blocked. But there is no explanation, and I will get peep if my transaction is blocked. So regulator, central bank correctly states that you cannot deploy any AI, and AI in natural language processing is basically the same. So how do we overcome that? How do we make the AI systems, natural language processing systems, trustworthy? That, you know, just throwing in percentage that AI is better by X% than human will not work. You have to explain the decision was made because this, and that. And unfortunately, AI is a black box. You cannot do that. For the Lithuanians in the audience, maybe you saw the just recently in one of the news portals where was a message that the girl's transaction was blocked and she had problems because she in the bank transaction message she wrote sex, drugs, and rock and roll. Okay, AI might have passed through that transaction, But the regulator said, if there is a sex word or drugs in the message, block it no matter what, and then send it directly to police. So, yeah, I mean, we didn't solve that yet. Yeah, with transactions and then trust in AI, and that's, to me, it's the main kind of, I think in law it's the same. There is no, I'm not aware, probably you don't have the central law institute like central bank, but there is still probably heavily regulated or overseas industry. Yeah, so this is the kind of, you know, the blinking font of trust. Yeah, I was already referring to that. There are no silver bullets in this. So if you will have a solution developed for the divorce cases, if you will deploy it in other area of job disputes, it will not work. Because in divorce cases, the metal fan means one thing, and in the other slightly different area, it will mean totally different thing. What does that mean? Cost. Because for each law area, you will have to deploy your own different solutions. So it might be good in, you know, in the, again, some kind of a research area where you say, yeah, we reach the perfect solution. But then when you will start calculating dollars, euros for each area, maybe it's better to hire humans. Okay, if still you want to do AI and NLP, the first thing to do is just to spend days manually going through documents with a marker and marking each kind of, you figure out the algorithm and you just mark it with the markers in Word document or whatnot. Kind of pretend to be the machine, yes, devise the rules, and go day after day, marking, annotating, and not sending directly to Mechanical Turk. Just yourself trying to testing your idea on actual tests, on actual documents. And very quickly it will start kind of falling apart, and all sorts of exceptions will emerge. So yeah, so that's you know, one of the, again, kind of the recurring theme, but there are no really standardized, really good algorithmization strategies when working with text. And be ready for all sorts of unexpected scenarios. And worse, even worse, when AI fails, it fails spectacularly. It's not like it just, you know, gives you incorrect answer. It will give you like really bad answer. And we saw the lots of scandals with the Google calling black people all sorts of names, or, you know, self-driving cars mistaking road signs for refrigerators. It's like it fails in, like, you know, fireworks. So again, with that, and there is no escaping from that with the state of the art of the technology. So when building those machines, those kind of solutions in real environments, business or court environments, we have to be ready for those spectacular failures. I don't know, in courts, someone artificial intelligence pronouncing some really wild things, and there has to be an organizational process in place how to deal with that. Yeah, so I was kind of looking at the clock, and yeah, just quickly going through the presentation. So hopefully it was quick, somewhat useful, and if you will have any questions, feel free to. Yeah, thank you.
Critical speech. I have a part question for you after that, and but now, yes, question time and discussion about the wounded knee of ODR, that is the consumer. I mean, the consumer EU regulation is the wounded knee of ODR. Anyway, I would ask after about that after the discussion of our speeches. Anybody has a question? Yes, please.
I mean, you know, I like asking questions. So I have a question to Zygmuntas. So a lot of the advancements in AI, when you look at it, like, you know, reinforcement learning or self-driving cars, usually the beginning is in a very, very well-defined niche. Also with Google Duplex, now you've seen, you know, they say, oh, AI can make a calls, but only to certain kind of restaurants and certain kind of situations. Do you think maybe that's the secret sauce for text processing? Because we always try to swallow it as a whole. And I know that because we do the same efforts in healthcare, and we fail also spectacularly because we try to comprehend it all. Are you working on anything that, you know, sort of focusing on a very niche area and then trying to grow it as, you know, as, let's say, Google does?
Yeah, so that's a good summarization of how the progress was being made in deep learning. That's basically the area which now makes huge improvements. And with text, or with any actually AI situation now, I think that deep learning is kind of after this meteoric rise is now kind of reaching this plateau. And with the text, I think what you need to solve with text is all kind of rules-based semantic reasoning. It's not like with images where you have millions of them and you just recognize cats or cancer cells from not cancer cells, which are isolated fact in the image. And that's a kind of a wild success. It's progressing step by step and quickly. But with text, although there are also we see a lot of you know, improvements, but due to the fact that we are dealing with very, very different modes of understanding in text, long range relationships in text. Like I might define something in the first paragraph, and then it will develop down the text into something else. And this kind of long memory, dealing with long relationships is totally out of the radar of the current AI techniques. And there is a fantastic debate going on now between Gary Marcus. This is kind of a guy has a background in psychology. He created his own startup in AI and sold it to Uber. But he's more this old style AI proponent of saying, okay, we cannot do everything with deep learning. And we have to bring back this semantic reasoning, semantic rules back into AI. And against him is a Facebook raccoon who is saying, okay, this is all nonsense. We should pursue this deep learning, the deep learning paradigm with small improvements, like you are saying, in one and another area, and at some point we will reach breakthrough. I don't know. I really don't know who is right, but I kind of lean towards Gary Marcus area, where I say, okay, what we need is not to blindfold us to this one deep learning technique. We need to bring into the AI kind of orchestra of different techniques, and then we might have something. Hope it's kind of useful.
Yeah, Francesco, if I could just not ask a question, but just reply to the question that's actually printed here after Q&A, which is why EU law is failing on ODR consumer. I just want to give, I think, four answers to that. One is state organizations responsible for consumer rights and what have you are, I find, certainly in the UK and other countries, not really informing retailers and business of their duties that I mentioned earlier. Two, they're not enforcing, so we need to inform, and we need to enforce when companies breach the law. As I've said before, there's only 22% compliance, and more than that if you agree that burying the link in the terms and conditions where people don't read isn't really complying. The other thing is that I think there's a compromise in the European Union Parliament, when they made
whilst they required companies to provide a link for dissatisfied consumers so they can be referred to an independent ADR organization operating online, they didn't make it compulsory on retailers to participate in this system of ADR. And that really was, this whole legislation was intended to increase confidence in cross-border purchasing within the single market for consumers. That very fact of not making it obligatory on the retailer to participate is actually risking less a reduction in trust, not an increase. And let me just explain. If, unlike burying it in the terms and conditions, you did what I consider the proper thing and put on your website, these are our products we sell, and by the way, if you're ever unhappy, click here and you'll be referred to the European Commission's special ODR website that will refer you to someone who can resolve the dispute. And what happens is somebody sees that and they think, I think I'll buy from this site rather than one in America or somewhere outside the European Union. Maybe the UK one day, hope not. And feel confident and have trust in that very link to a EU authorized ADR body. Then after he buys, or what do we hear about the heels that were not on the shoes? Well, maybe that was a she. And remembers that link in the website that gave her trust to buy from the site, clicks the link, fills in the information. The next thing, and this is happening a lot, I hear a lot, he gets an email back from the European Commission saying, I'm awfully sorry, but the retailer doesn't want to participate. End of story. Oh, hang on a minute, I bought from you because you had this European Union seal there and a link to a European Commission regulated ADR body. And that's, that's, if you like, the third thing, that they must make it compulsory. What is wrong with requiring European retailers to have to participate? They're not, some of these ADR bodies may be providing a form of online mediation, others an online arbitration, so they may be bound by the decision. But what is the objection there? And I wonder whether that making it non-obligatory to participate came out of the retail industry lobbying during the period that this whole legislation went through the Parliament. So there are the ways in which I feel significant progress can be made, making everybody know about it, enforcing when companies don't do it, making it obligatory on... And one final thing I should say about Lithuania is I had a look on the Commission's website where it lists the various approved organizations. In the UK, there must be about 50 different independent ADR bodies that are providing services and are listed and you can use according to different types. In Lithuania, at the moment, apart from, I think it's 3 regulated statutory bodies like for banking, for energy. Oh, is it somebody else? Okay, that's the second person who's slipped there. Some good claims against university. That there's only one, apart from finance and energy, maybe telecoms, there's only one general consumer, which is the National Consumer Organization. So there's no competition for them either. It needs to be breathe some life into all of the whole. We've got the principles there. And I feel the benefit of a properly operating consumer ODR service through these rules and regulated by these laws from the European Union will itself make great awareness of the public of ODR generally and will boost the developments of ODR, of algorithmisation of dispute resolution and all sort of techniques there. So those are the thoughts I'd like to leave.
Thank you, Graham. Somebody would like to give an answer or agree with Graham Ross? I agree with you, but I have a question. So maybe we can simplify the regulation about the consumer law, the European consumer law, and it will be an advance for the ODR, and of one side, and on the other side, make it obligatory for mandatory for each law for each business dealing in United Europe. So, and in this sense, obligatory and or mandatory and simplified regulation, we can get our goal. So I hope. Anybody on the topic? Because it was quite the first attempt to introduce the ODR, but it has no result, no good results. Okay, I could say you could maybe it could be a great achievement of this workshop. You could maybe write down the change in regulation. Why not? You can write it down, and we can present it. Why not? It should be simple. It should be not so difficult. I mean, if you mean so we have to make it mandatory, obligatory.
Everyone conflates the word consumer, so we're talking here about the law on consumer, with low value. Yes, of course, most of the consumer matters you buy in shops of modest value that wouldn't normally justify the cost of legal action or whatever. But that's not the definition. The definition of what is a consumer product depends on the purpose of the buyer in buying it. In other words, was it bought for the purpose of business, trade, profession, or craft? That is actually the definition in the regulation and directives consistently throughout Europe. What that means, therefore, is these rules that would promote online dispute resolution and therefore make it much easier for people to exercise their rights there, would apply equally to the sale of an ocean-going yacht or the installation of a swimming pool in your house, all items that will well justify litigation and give plenty of worthwhile employment for mediators and arbitrators, even who might normally shy away from consumer as not being their field because of this idea that it's low value. These rules would require somebody selling yachts, and now, okay, allow for the fact that most people spending multi-million pounds on a yacht might want to put it through their companies for tax purposes. But the point is, any high-value jewelry, whatever, that the companies selling these things also need to comply with this legislation because they're selling goods being sold for the purpose other than business. By doing that and encouraging that end of the market, you're making even greater progress in introducing ODR into the culture. It's all about culture. That image at the front of my presentation of the two men arguing, saying, see you out of court, this is the whole point, that ODR has got the ability to change the culture of dispute resolution and to move away from see you in court, which is the usual emotional solution people feel when they want to pursue their things. I think ODR does have that ability once it's ingrained, once people are seeing what's available, and this wonderful law that actually was really turning hundreds of thousands, millions of businesses all throughout European Union into people helping to market ODR, because of course they had to have this link easily accessible. And if we made it properly accessible, people will use it more, and therefore people will understand ODR more. It'll be more quickly ingrained. We all know if we close our eyes and open up again in its 5 years' time or 10 years' time, of course we're going to have most dispute resolution done online. It's just a question of how we get from here to there.
Somebody else? Anyway, if I may say something, you can have a system of ODR system with consumer law, but not with this consumer law because there are too many mandatory rules, and so we have to construct in this case. If you want an algorithmisation of the resolution here, online dispute resolution, you have to describe exactly in a system, in a expert system like this one presented before from Simantas. You have to describe exactly all possible cases. So the semantic is impossible here. There are too many mandatory rules. If you want an algorithmisation of this, or the solution of this dispute between consumers and business, then you have to give more free space for the solution. Actually, there is no free space. So the impression from the consumer is, okay, I have a father who is caring to me, or is taking care to protecting me. And the father is the European Union, but the protection is totally ineffective. So if you take away some protection, gives the party the possibility to defend themselves, or to find an agreement with the other party, with a true third party, which could be an algorithmic system. I think here we have some possibilities. Otherwise, algorithmical, no. There are too many mandatory rules. You have to take it away. Or online dispute resolution, but not leaded from algorithmic system. Yes, please. I know I provoked you.
Well, let me make a defense of mandatory rules for consumer protection. Yes. If you do not make those rules mandatory, they're not going to be adhered to. Their purpose is consumer protection, which is why they are mandatory. And they are there for a reason. Taking them away will reduce the level of consumer protection. So try and think of if that is what you want to do. Do you want to reduce consumer protection just because you can then algorithmicize the dispute resolution? That's a trade-off, I don't know.
Okay, I answer right now. No, I want the contrary. I say, together with Kram-Ross, if I understand right, this legislation is not effective. The consumer is not protected. This is my problem. This is the contrary what you said. And I ask me why the consumer is not protected. It's the same thing with the privacy. Is your privacy protected? I don't think so. Is no legislation in privacy? Of course there is a lot of regulation. Are we protected from this regulation? No. Why not? Who has failed? We, jurists, thinking that our method in protecting privacy or consumer is the best one. I don't think so. I think there are other possibilities. We have to try it. We cannot go on in this way. If you are pursuing this goal, I want to protect consumer, okay, you have to admit that this regulation doesn't.
I think that the best way to protect consumers is by making sure that, for instance, in the online purchase procedures, they are protecting the consumer by design. That is the very best way of doing it, because that will avoid disputes. If all you do at the end is streamline disputes without doing anything at the front end, that is not going to be protection. So if that's what you mean, I agree with you. But protection by design is the way to go. And I think information technology can play an important role there. But still, we need mandatory rules to protect consumers because they are relatively powerless, which is why the rules are mandatory.
Yes, please.
One other thing, if I may. Other solutions appear to be developing naturally. So, in the sense that many people say, and I've used it myself with some good effect, that one excellent way of pursuing your consumer rights is through Twitter. Most big retailers and companies monitor social media references. And to say you've got a complaint and to issue it, you'd be surprised how quickly the companies will respond to that. Now, in one sense, that's a good thing. And the whole point about the whole issue of consumer reviews is an issue. But I think both those things are creating a sort of, almost a sort of consumer war zone that actually leads, it doesn't apply to big retailers because they see the sense in, you know, readily dealing with complaints, letting you change goods, no problem, no question asked. That's good retailing, generally, but it's the rest of the market. But I think the problem with a lot of these other informal, reputation-based expressions of anger at something from a retail product or service, it covers services as much as product, may, to some retailers, generate a sort of feeling that they need to protect themselves, and I think just having what is a very well worked out system, apart from the fact that it's not obligatory, requiring the participation will probably take a lot of that heat out of it, as long as people can see that they have some acceptable route for those companies that don't readily return their monies.
Okay, I agree. Yes, there are some possibilities, but I agree with the possibility of the need of using the by design technique. So to design the law with the technique, together with the technique, in order to have technique which implements law. And in that sense, we can do mandatory the use of the feedback from the service that somebody has become. If we do that, we can make it mandatory. We can have an amplitude, so amplify the results, the effects, the good effects of the reputation, bad reputation or good reputation. Yeah, that's right. I agree with you. Yes. Any other suggestions? No? It's an important, I mean, it's quite important. You are a consumer or not? Yes, you are. But you don't care. Or what? Okay, and another question for you. It's interesting, this experimental way to approach the feeling with artificial system and a human one. And the CREA project, we have a part dedicated to that. And in a system, in a legal system where the confidence to the judges is not so high, which is our legal system. And the confidence to justice is not so high. So I think we will have these results that you are looking for, and then we will compare them. Perfect. Thank you for your speech. It was really interesting. Some other question? No, then I will let the microphone to Rimantas and Marco for the final.
Well, I just try to be super short. Let me just thank you all these amazing speakers that we have, because really when we decided the topic, Rimantas and I, we expected a good number of answers, but we didn't expect it. So many speakers that are really interested in this topic from really on a big and heterogeneous point of view. And secondly, lastly, of course, I have also to thank this perseverant public that is still here at 6 o'clock. And to just, as a closing remark, I would just say a super short story about perseverance. Because Rimantas and I, we met in 2013. Just, I think, a few people here, they knew. So, in 2013, I was just a freshman, like at the beginning of my PhD, under the supervision of Professor Romeo. And we applied together for the first time for an European project. And of course, we didn't get it. But why perseverant? Because we were perseverant, because we did it 4 times. And in 2016, we get what you read until now, CREA, there. And now it's 2 years that we're working on it. So that, as also a closing remark that we did, yes, in our interim meeting, as Mirez was saying, yes, we should keep on going like this. We should be perseverant, because it's also with perseverance that we can get results. I'm not telling you that we will get everything with CREA at the first attempt, but I can promise that even if we fail, we can keep on going. Thank you.
As a recap for, well, closing of the conference, from my perspective and from a point of Vilnius University, I would like to thank you everybody for coming to this conference, for listening and watching us live stream online. Thank you very much for speakers, for sharing your views, your ideas. As you have seen, well, many of presentations showed us quite eclectic view of the landscape, developing landscape quite rapidly, of online dispute resolution, algorithms, use of AI as more sophisticated tools of algorithms with a broader concept. Some of the projects are very focused and very specific, as you've heard. The CREA project has very narrow focus with quite clear aim to do what's doable, what's realistic. And it has been already done, not in this context, but in different contexts. It has some level of success in different jurisdictions, such as Australia. We know John Zeleznikov's work, which has been mentioned by Graham. Yes, I've read his articles about what he's doing with family divide and some other tools which apply part of the algorithms we're also discussing. Still, we're trying to design new algorithms. So it's doable, it's workable. It might be even flying with well, limited application, but in the very narrow sense, in the very narrow sector. Now we cannot talk about the super AI judicial system or judges replaced by robots. No, that's not for now. Maybe science fiction fans can discuss about this a little bit more, or authors of that books. That's also an interesting topic. But currently, down to the ground, we see that there are lots of issues which remain unanswered, and we are together in this type of gatherings, in doing various R&D projects. We are going to answer these questions, and we are answering them. For example, in our project, yesterday during the more detailed workshop, so what are we doing, what particular criteria we should take into account, what about psychology, what about sensitivity of interaction with certain algorithms or certain tools we're going to design, what about implications that time skew and how to integrate in the algorithm. We had lots of questions which might be answered and will be answered in the future. In trying to build up and pilot certain programs. And what has been observation by Graham in the very first session as well, very good presentation, giving you a feeling in the landscape, what are possibilities and potential of ODR systems, which some of them are equipped with some algorithmic support and basis. He also noticed, and we had discussion with many of the colleagues, that majority of these initiatives, they fail. Well, we're not talking about ideas which has not become and took a shape of an initiative, but some of these we are going to make a breakthrough. And if we're not going into this shaky path, shaky route of innovation, where many of our attempts will fail, we are not going to make progress, we are not going to evolve to something. And production of very tiny, small steps towards making our life and life of our clients, our customers, our colleagues, our friends easier, that's the route for innovation. And that's very important to keep the doors open, to keep your minds open, and keep your hearts open, as my colleague Michel De Stefano from Miami and Harvard Law says. These are 3 keywords for innovation. Make everything open, and that will happen. And I believe if we will be persistent enough, as my colleague has already told to you, we were persistent with that project to fly, yes. I believe we will be persistent to make it to some result. If we will continue, if anybody will continue that work, because we are not going to make a commercially used product. What we are going to create here in this particular project, we are going to create a part of the engine, the very core of the engine, which might be installed and fly, maybe into car, maybe into scooter, maybe into a plane or whatever. And if you will upgrade that engine, that might be flying in, well, different fields, different sectors with different devices, etc., using the same methodology and disclosing the large scope of various issues which still remain very shaky, very doubtful. Would you allow, for example, this algorithm equipped or non-equipped with artificial intelligence support simulating human behavior and some implications of human behavior or not? Would you be in need of human to verify the final result, decision, etc.? Or would humans be comfortable enough to apply this type of engines on massive scale, resolving our disputes and allowing millions of disputes resolution without even a glance of a human being? I make a small provocation to you, yes, with this voting, whom you would like the most. And what I noted very interesting phenomena, which I expected as well. So that was not the main result that somebody voted for one part of the picture and somebody voted for another part. The less amount voted for this part of the picture, with a picture of, well, robot judge, yes. The majority of you has not voted at all. What it means? We have a large space for thinking, for discussion, for making even philosophical, theoretical research on the basis, what are we doing? And by the way, this is integrating, and our colleagues as well, they're going very deep into very basis of what law is about. On the very cells level, on the quantum maybe level, to what is law about, what is lawmaking about, how to quantify normativity, yes? This is one of the substantial issues, which is also important. How to quantify, maybe you can quantify emotions of humans when it comes to the dispute resolution. For example, for our project, it was very interesting implication. We discussed, okay, you can calculate various market prices, some stars or some points parties will give as a preferences, indicating their personal utilities or personal values to this particular, for particular items of assets. But how do you quantify your emotional relationship or just emotion with a cat? Which might be two spouses would like for each other, or how you quantify your relationship, which is more sensitive and more complex with your child. And this is not only emotion, this is more broader factors, yes? We're not ready even to ask these questions, and I believe we will be asking in the nearest future, because this hype about artificial intelligence makes us to think about it. we see various charts, various other projects going on, and various researchers going on, even trying to look a little bit in the future and tell us how you would interact, whom you would trust the more, as colleagues did, robo-lawyer or robo-judge or human judge. Yes, it's a bit premature, I'd say, but very interesting, because this, looking into the future, will give us very important answers today how to design the system. And by the way, it is serious. It is not only a matter of science fictions for authors of science fiction's book to deliberate about or give us our ideas. It is very serious. It is now. And that's why even international organizations started to make up standards. And we see that these standards are very fresh ones. European Parliament looked into the smart and adopted resolution about robotization in various activities only 2 years ago. Council of Europe, which is very concerned with fundamental human rights, at least in the European continent, looked at this particular matter in very narrow sense, only artificial intelligence, not the broad scope of algorithms or whatever, only artificial intelligence, 1.5 months ago. Yes? They started to set standards, and this was serious because if you will read these studies on which this, for example, ethical charter on use of artificial intelligence is based, it's very interesting report, it's very interesting study, looking at the current role of play and telling, could you trust these artificial intelligence systems, for example, for prediction of judgment? Because current systems which are not commercialized systems are not so successul. One of the best systems can provide results with 79% of trustworthiness. What might be the outcome of European Court of Justice, European Court of Human Rights decision? Well, 79%, okay, up to 80 maximum. It's quite high. But when we discuss this now, it's insufficient. Why? Because if you just guess, blind guess, you will receive 50%, at least, yes? So 30% on top, it's not much. And we discussed with colleagues that this artificial intelligence application in image recognition started to boom, then percentage from 70 or 60 came up to 95, 96 or higher. But it happened in a decade. It happened in a decade. We already have a presentation, and that's why it was very interesting to invite Žygimantas to tell you about what the progress can be made in semantics, which is the core of what is law about, yes, what we're doing. As well, there are different other things, because it is connected, but, well, there are a variety of other things, such as logics, ethics, moral, religion, etc., etc. A huge thing, not only about understanding language and the logic behind, but also huge other things, which might be simulated or might be not simulated by machines. But it is very precautious prediction, which came out even before with our discussions with such notions about technicians working with artificial intelligence tool. They tell, look, we truly believe that most probably in upcoming 10 years, this artificial intelligence semantics might be potentially breaking through at the same level as artificial intelligence application in image recognition. And if it happens, most probably all this system of prediction, of characterizing of lawyers and all other stuff, more working and concentrating on language, on working with language, processing it, and making some language as well, analysis things, will be breaking through as well. Then we will not have robo-lawyers, not yet, but we will be having certain engines, which most probably, in not very far future, will be installing such systems as Liteko system, Liteko 2 or maybe Liteko 3, But before, we need to answer a huge scope of issues that have been answered here, asked here, and even not asked here. And many of them are the fundamental, are the basis connected to human rights, to our well-being, and to ourselves, trying to make our lives comfortable and provide better service as lawyers, whenever your capacity, and receive better service as users of the systems of dispute resolution. Thanks a lot for coming here. I hope that's not an end. That's only an end of one event. I hope we will continue our discussions in future forums, in different locations, and maybe someday in this location, hopefully not far away. Thank you. Stay in touch.